Good afternoon, ladies and gentlemen, and welcome to the Public Service Commission of South Carolina. We're here in dockets number 2021-143E and 2021-144E. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Powers, Belzer, and joining us virtually, we have Commissioners Caston and Thomas. Before we broke for recess yesterday evening, we had Witness Duff on the stand. And we were at recross.
Excuse me, Mr. Chairman.
Mm-hmm.
This is Attorney Emma Clancy. Before we resume testimony, I did just have one brief preliminary matter to raise. I was hoping to request to be excused at 4 p.m. today for the remainder of the hearing due to a family engagement and travel that can't be avoided, unfortunately. Attorney Kate Mixon will continue to appear on behalf of the Clean Energy Interveners through the remainder of the hearing.
All right. Safe travels, and you are excused at 4 p.m.
Great. Thank you so much.
All right.
Mr. Chairman, Jeff Kirkendall for Solar Energy Industries Association. Mr. Turini has a similar request actually to be excused from the entire hearing today. He is counsel to a Senate subcommittee that is meeting today.
All right. Mr. Turini is excused.
And Mr. Chairman, this is Andrew Bateman with ORS. I also have one quick preliminary matter I'd like to raise with the commission. I believe during Mr. Morgan's testimony a couple of days ago now, Commissioner Belser pointed out what she believed to be a typo. Witness Morgan has confirmed it was in fact a typo. We could file revised testimony with that corrected if the commission would prefer, or we could let it stand on the record that Witness Morgan acknowledged the typo. We're happy to defer to the commission with whichever is preferred.
You can file the revised testimony.
Thank you, Mr. Chairman.
All right. And I'm sorry, I said recross. Were you finished with your direct?
I'm not finished quite with my redirect.
Redirect, yeah, okay. All right.
Thank you. Or, yeah, unless y'all aren't done with commissioner questions.
Okay, that is right. Thank you. Commissioner questions. Commissioner Williams.
Thank you, Chairman Williams. Good afternoon, Mr. Duff. Good to see you again.
Good afternoon.
Thanks for your endurance. I have two questions. They're kind of nitty-gritty. There's been some discussion about the purpose of requiring that the customers be all electric in terms of their use, and I understand why at the big scale. But I'm curious if you all looked at customers that use some form of gas or any other combinations, and whether the numbers just didn't work, or why you decided from that perspective that it needed to be all electric.
For those very reasons you discussed. So one, we looked at the total amount of consumption that could be potentially reduced, and obviously all electric customers were going to have
Right.
more consumption that could be reduced. But then again, the all electric customers have that winter heating, which is then able to be controlled with the BYOT. Again, it's really important to think of this as a total package because it was designed in that manner to be kind of synergistic between the different elements.
Okay. And kind of a similar nitty-gritty question. I believe that in the application it identifies that solar providers who provide leases, who own the solar equipment, are able to participate. Did the numbers there also make a difference from a receptivity from the free rider perspective?
Yeah, so I think we did not include the costs of leasing and the fact that it would kind of reduce that upfront cost for customers. Again, we were trying to be conservative, but to your point, we believe making it available to customers to choose to lease will make the program potentially more attractive. So again, we were conservative in not really factoring that into our modeling, but it is available to them because we do believe it creates a potentially more attractive offer for customers and could increase participation in the program.
Who gets the incentive in that case?
So if the customer chooses to convey it to the leaser, the incentive would go to the customer, but obviously they could have a contractual agreement where they would relay it to the leaser.
So the attractiveness of it happens when the leasor conveys it to the leasee.
Well, because it would reduce the amount that's being leased. Exactly. That's correct.
Okay. Thank you very much. No further questions.
Commissioner Powers.
Thank you. Mr. Duff, I just had one question. If this program was approved as an energy efficiency program, what impact would it have on the monthly bill of a non-participating customer, the average customer?
It's a little bit tough to say because the amount that will actually go into the rate for the 2022 participation, it won't be filed to go into the rate, which is part of an overall rider, until 2024. So because we reconcile 2022 with 2023 expenditures, so I cannot give you an exact amount, but I can tell you that you're looking at if we hit the participation projections that we had, the program cost between DEP and DEC, I don't know the exact split between them, but it's approximately $2.5 million for the incentives to customers and the running of the program. So that's not a huge number with respect to the overall portfolio. Now, I don't want to say it's insignificant, but it's not like it'd be 50% of the rider.
Okay. But it would affect the customer's bill.
For non-participants, but they also would potentially be seeing benefits in their base rates and fuel charges associated with savings that would be realized by all customers on the utility system. So again, it's a little bit of a challenge to put that together. Looking at the RIM test, which is looked at again to look at non-participants, it appears as though the long-term pressure on rates when comparing the program or not comparing the program, it would actually be positive for DEC and just very 0.97 versus a 1.0 ratio for DEP.
Okay. So in the future, there could be some benefit, but it will cost customers money.
It will cost customers money, but there will be benefits, and the money will not actually be charged to customers from 2022 until 2024. So,
thank you.
All right. Any more commissioner questions for this witness?
Chairman Williams.
Commissioner Caston.
I'd like to ask a question or two, if I may.
Yes, you may, sir.
Can you hear me okay?
Loud and clear.
Mr. Duff, can you hear me okay?
yes, I can, Commissioner Caston.
Good, I'm glad, thank you. Yesterday, I think, as I recall, you labeled ORS witness Ori as kind of out of touch with the South Carolina utility landscape. But if I understood you correctly, DEC and DEP, they use the California Standard Practice Test in determining cost effectiveness, correct?
So yes, the company uses the industry standard accepted tests, which are based off of the California Standards Practice Manual. That's not to say that we follow California's rules. They're tests that were adopted in South Carolina rules, but those tests were originally developed in California.
Okay. But I guess one thing I'm having trouble kind of wrapping my head around, excuse me, I'm sorry, is the TRC test includes cost to the participant of a potential program. Doesn't it make sense to consider cost to participants in a program? where participants must, take on such a significant investment?
So that's a great point, Commissioner Caston, and that's why we think that actually it's more accurate to look at the UCT, the participant test, and the RIM test to give you actually an understanding of how the customers are doing. And if you look at the participant test results that was in my rebuttal testimony, again, the participant test for DEC is a 0.99, which means the benefits are are almost identical to the cost that the customer receives. And on DEP, it's a 1.11. So the point of the matter is the TRC does not necessarily give you this holistic view. It's actually more accurate to look at it from a utility cost test perspective and then look at it from the RIM and participant test, because then you see where there is a potential shortfall of the cost versus benefits and whose perspective it's actually having.
Commissioner Caston, are you muted, sir?
Yes, I am. I assume you couldn't read my lips. I apologize. So, Mr. Duff, are you saying that the TRC test is not a good test to use for this?
I'm saying that I don't believe it's as witness Ori said, a more accurate reflection. I actually think that if you really want to understand how both non-participants under the RIM test and participants and the utility system, which areas there are potential subsidies or non-subsidies, that's the more accurate way to look at it. But again, the company and all the parties that agreed to the mechanism felt that the utility cost test was that primary test that should be looked at in determining whether a program should be offered. Again, Commission should consider and look at all those tests. My only point is the TRC masks where there are potential excess benefits and excess costs. If you look at the granular participant and RIM test, you can see where it is. And that's the exact point of why you should look at all four tests.
Okay. I'll ponder that some more. But thank you very much, Chairman Williams. I have no more questions.
All right. Any more questions for Mr. Duff? Now redirect.
Thank you, Mr. Chairman. Mr. Duff, good afternoon.
Good afternoon.
Commissioner Powers asked about the impact of implementing the program on customers' rates, and you mentioned $2.5 million of customer costs. What are the total estimated savings from the program?
So if you look at my direct testimony, I have to go back and look to give you the exact numbers. So,
Mr. Chairman,
as
I'm going to object. I believe that Mr. Wellborn's redirect needs to be limited to the scope of party cross, and I believe this question goes outside of that scope.
Mr. Chairman, throughout the course of this hearing, we've been permitted to ask redirect as related to commissioner questions. I'll defer to you if you don't want me to go through this. That's fine, but that's been the MO so far.
I will say, Mr. Chairman, that earlier in this proceeding, Mr. Wellborn had objected to me doing redirect beyond the scope of party cross, and that objection had been sustained.
Mr. Chairman, my memory is that I objected to his recross because it was outside of the scope of my redirect, which is a different matter.
Okay. So, without going back and reading the record, the position I usually take is that redirect is allowed to address questions answered or asked by the commissioners. I can't go back and remember that exact issue, Attorney Knowles, but redirect has been allowed to address commissioner questions. So your objection is overruled.
Mr. Duff, have you found those savings figures?
Yes. So based off of the 5-year totals of the program, the company estimates that DEC customers from the utility system standpoint would benefit from $26.5 million, and that's a net present value number, so it could be a little bit more when you get out into 5 years, but it's an NPV number of $26.5 million, and DEP would be $3.9 million versus a cost of $10.5 million for DEC customers and $2 million for DEP customers.
And can you take a step back and explain to the commission at a high level how EEDSM programs work in terms of costs and savings?
Sure. So with respect to the cost side, it's going to reflect all of the program costs that are incurred to administer and provide incentive to customers to participate in the program. So obviously the majority of the cost in this case would be associated with the incentive paid to customers. Then you would also have the cost of the evaluation, measurement, verification, which would be done by an independent third party. We really don't want to call those kind of the program costs that customers get because they're not directly going to administering the program or delivering, but more the verification. But those costs are included in the modeling. You then have the avoided cost side. This is taking the modeled energy savings and capacity savings associated with the measures. So in this case, the smart thermostat for the DR side and the solar PV panels, and looking at those energy savings versus when those savings occur, and then calculating the peak reductions and energy reductions that are then used to calculate the avoided costs. The avoided costs come from, consistent with the mechanism, the avoided cost rates that have been approved to be used in the program, which would be avoided energy and avoided capacity, as well as avoided T&D rates.
Thank you. Yesterday, Commissioner Belzer asked some questions about the transition to the utilities cost test and generally how that preceded this filing and the applications in this docket. Do you recall that conversation yesterday?
Yes, I do.
Can you please explain the EEDSM mechanism review process and when that process was started in North Carolina and South Carolina?
So the mechanism there's been basically 3 EE mechanisms for DEC. There was a Save a Watt program, which the entire portfolio of programs as well as the mechanism expired. And then there was the mechanism that was put in place in approximately 2014 for DEC. And then the model was updated for their model was updated upon right after the merger with Duke Energy to be a little bit more consistent because there were a lot of differences. Those models have been in place again since approximately 2014 and 2015 for DEP. They've been in place until we had to do a review consistent with the last approval of the mechanism. And so we looked, and obviously we work with stakeholders on a regular basis to try and understand how the mechanism and how the portfolios are working. And generally, we felt like the mechanisms were working quite well. Duke Energy Carolinas and Duke Energy Progress have been lauded as being the leaders in the Southeast, which we're very proud of, for utility-offered energy efficiency programs. But we looked at the mechanisms and said, how can we adjust those mechanisms to make them more effective given kind of the changing landscape of energy efficiency? And so one of the things that we had noted for quite some time was that programs with high upfront capital costs for customers struggled under the TRC because it didn't matter what we changed the incentive amount to. It wouldn't, because the incentive actually is looked at as a transfer in the TRC. So things like air conditioner programs where you were seeing advancements in energy codes, they were falling out of the wayside. And the utility and stakeholders felt it was really problematic to have a mechanism that would basically rule out such integral measures such as HVAC. So parties talked about the UCT as being
Objection, Mr. Chairman. That's he's testifying to hearsay.
I'm not sure I heard the hearsay, Mr. Chairman, so I'm not sure how to respond. He's responding to the redirect question that I asked.
He's
Yeah,
testifying.
he said party said and testified to.
We can strike that from the record.
Okay.
I assume
Sure,
that can be
sure.
rephrased or changed.
Yeah, sure.
Objection
So-
sustained.
As part of the stakeholder process, the company learned that this change, along with other changes, including a reduction in the PPI percentage, the portfolio performance incentive, which we discussed yesterday, the company and parties agreed that one of the problems was that the mechanism wasn't appropriately promoting low-income programs. So,
I'm going to object again.
sorry,
on the ground-
sorry for parties. Stakeholder feedback.
Mr. Duff, allow counsel to
Oh.
state their objection. Your lawyer will respond, and then I will rule. Yes,
Again,
sir.
object on the grounds of hearsay.
And Mr. Chairman, it's a little bit of a fine line. In this regulatory sort of stakeholder process, the company takes feedback from its stakeholders and attempts to modify its programs based on that. I understand the hearsay objection, but that is also part of the process that Mr. Duff in his role with the companies has to engage in.
I understand, but we still need to try our best to comply with our rules. Mr. Duff, if you could testify to what the company or what you learned as opposed to what a party or someone other than yourself said,
Okay.
that will help us along.
Yeah.
Thank you, sir.
My apologies, and my apologies for interrupting. I knew the minute I said parties, so I apologize.
No worries.
So the stakeholder process led us to understand that we didn't feel like we were promoting low-income programs enough through the mechanism. So a incentive to offer low-income programs was developed called the PRI, or Program Return Incentive, or Performance Return Incentive for low-income programs specifically, which are programs that the commission would approve that don't pass cost effectiveness. And in exchange for that, again, not trying to earn undue return, the company agreed to reduce the PPI amount from 11.5% for DEC and 11.75% for DEP to now a uniform 10.6%. Those conversations started in 2019, went into 2020, and then we were able to reach a settlement in North Carolina around those terms, as well as in South Carolina. The one caveat was in South Carolina, in response to stakeholder feedback, we removed the bonus incentive for achieving 1% of annual retail sales, which was a component of the North Carolina mechanism. There was a bonus and a penalty in those mechanisms associated with either exceeding 1% of annual retail sales or falling below 0.5% of retail sales. And again, through the South Carolina stakeholder process, in order to reach settlement, those were removed.
Thank you, Mr. Duff. Just one last question. Yesterday, Commissioner Casson asked whether the companies had engaged with the ORS ahead of its collaborative meetings on this issue. Was the Solar as EE program fully fleshed out when it was presented to the collaborative or not, or was it more of a straw man proposal? Can you please explain sort of the status of the program proposal at that November meeting?
I'm going to object to Mr. Duff's testimony describing the ongoing workings of settlement communications. That's not admissible into evidence.
Mr. Chairman, I'll limit my question to the status of the proposal when it was presented to the November 2020 collaborative meeting.
Just so I'm clear, I know we talked a lot about the collaborative, or the collaborative has been discussed a lot, but this is the first time I've heard it, or that I remember, or maybe I've caught it being referenced as settlement negotiations. I didn't think the collaborative was a settlement conference or settlement negotiations, at least not the way that I understand it. Is that your understanding, Mr. Knowles, that the collaborative is
I had not
settled?
understood the collaborative as a settlement agreement. My objection was a little on the late side. Mr. Duff had testified about what the parties had agreed to arrive at the settlement, and so that's what my objection was directed towards.
Oh, as related to perhaps he's related, his issue is related to the mechanism settlement, Mr. Chairman?
Possibly.
It was the very last part of Mr. Duff's testimony. Then Mr. Wellborn subsequently asked his question. So I was objecting to the testimony that Mr. Duff had provided in the last sentence or two of his previous answer.
Okay. Well, sort of got by me there. Maybe sort of got by you as well.
Fair enough.
I want to make good rulings, but you need to make timely objections. Thank you, sir.
Mr. Duff, do you need me to
Yeah, could you
ask
please
my
repeat the
again?
question?
So yesterday, Commissioner Casson had asked whether he had asked about the status of conversations between the companies and ORS and other stakeholders, other parties, as related to the Solar as EE program, and also in the context of it being presented to the General EEDSM Collaborative in November of 2020. Can you explain to the Commission whether the program was sort of fully fleshed out at its presentation to that November 2020 collaborative meeting, or was it more of a straw man proposal? Can you just explain sort of the status of the program that's at that stage?
It was conceptual in nature, talking about the general idea of the program, the rough incentives amounts. Again, it wasn't formally modeled or packaged, and that's why it was again later shared when we could give more granularity. Again, the point of the collaborative and sharing it kind of in an early phase is because you're trying to get stakeholder input so that you can address concerns, potentially make enhancements to what the proposed design could be, and eliminate potential problems in the future. And then again, it was brought back when it was more granular and close to being ready to be filed.
Thank you, Mr. Duff. Thank you, Mr. Chairman.
Recross.
None from ORS, Mr. Chairman.
All right. Commissioner Williams?
I'd like to ask one other question. It's not too late.
Yes, ma'am.
Mr. Duff, I saw a note from yesterday that I'd taken and totally forgotten. Along the way, you said that you all, and you even said it today, that you were conservative in your estimations. And I wondered if you could give me some examples. You've given one or two, but could you
Sure.
run through a list, not in a whole
Yep.
lot of detail, but just to point a
Yep.
little bit more light on that?
Certainly. So with respect to doing the TRC analysis, we didn't try and put any non-energy benefits in with the program, despite the fact the mechanism said that we could put non-energy benefits in that would be approved by the commission. So we didn't even try and go down that controversial route, despite the fact other utilities such as Dominion have, in fact, included non-energy benefits in their analysis of energy efficiency programs approved by the commission. We included no spillover in the net to gross ratio, which spillover, market effects, and free ridership are in that net to gross ratio. We applied a 10% free ridership, but didn't put any spillover in. And even by Mr. Ori's own testimony, where he describes driving through a neighborhood and how people will see what's going on and adopt around it, that's exactly what spillover would be measured from this program. So that was another example. And then we actually had an internal debate. Our initial program modelers felt that there should be zero free ridership because, again, there's such low penetration of solar. It takes such a high investment from the customer, and the fact that it was bundled together with a 25-year commitment from BYOT, and DR programs have zero free ridership because obviously you can't get the incentive without the program. So again, 10% was a internal push to make sure we put in some factor for free ridership, but it was felt to be very conservative. For DEP, the number of customers that we assumed to be all electric, it's a lot easier for DEC because we have RE, which is an all electric rate. Rather than trying to rely on third-party data to carve out who is all electric for high-level modeling, we just applied the 45% that is DEC's RE rate percentage approximately. And so we actually believe, based off of that third-party data we didn't want to rely on, that it's actually higher for DEP than DEC. So again, the number of participants could have been higher, which again helps the costs of the program. And then, as mentioned in my testimony, we didn't assume any of the potential of the lease to lower that cost for customers, which again would bring up the benefits of the program versus costs. And then finally, again, we want to make sure that everyone understands, we assumed no value of exports. So obviously, there is the potential for exports for these customers. None of that economic value was factored in for customers. We're only looking at the reduction in consumption a customer would have versus the utility system. And so, again, we think those are all examples of how we were very conservative in how we looked at the program. Because, again, it doesn't make sense to be overly aggressive in your assumptions and then come back and learn that the program isn't cost effective. We tried to be very conservative, and again, that's how we are with our programs. That's why we don't project non-approved programs in the rider, because we know that it is customer dollars that are being spent on these programs.
And when you were talking about export, meaning you didn't consider any value to the energy that could be exported from the individual rooftop?
That is correct.
Okay. Thank you.
You're very
No
welcome.
further questions, I promise. Thank you, Chairman Williams.
All right, sir.
Just our next witnesses, if you're ready for that.
All right. If there's nothing else from Mr. Duff, sir, you may step down and you're excused.
Thank you.
And we're going to take a brief 15-minute recess for sanitation. Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in dockets number 2021-143E and 2021-144E. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Powers, Belzer, and joining us virtually, we have Commissioners Caston and Thomas. Please call your next witnesses.
Thank you, Mr. Chairman. We have a panel. We're going to start with witness Ford.
All right, Ms. Ford, if you would please pause to be sworn in by the court reporter. Yes, ma'am.
If you'll both raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Ms. Ford. Would you state your name for the record?
Good afternoon. It's Lee Ford.
Thank you. And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas and Duke Energy Progress as a regulatory energy consultant.
Okay. And what is your educational background?
I have a bachelor's degree in communication from Lenore-Rhine University.
How long have you worked in the utility industry?
I have worked in the utility industry for approximately 12 years.
And what prior roles have you held that are relevant to your testimony today?
I joined the South Carolina Office of Regulatory Staff in 2007 and served in a variety of positions, including a rates and regulatory analyst, manager of electric regulation, and as a deputy director for electric and natural gas regulation through 2016. In my various roles at ORS, I was responsible for reviewing and analyzing electric and gas regulatory filings, including energy efficiency and demand-side management filings, testifying before the Public Service Commission, facilitating stakeholder engagement and settlement activities, and monitoring legislative activities. I represented ORS at the Duke Energy Carolinas and Duke Energy Progress DSMEE Collaborative, South Carolina Electric and Gas Companies, now Dominion's, DSMEE Advisory Group, Palmetto Clean Energy, the South Carolina Solar Business Alliance, the South Carolina Clean Energy, and the South Carolina Clean Energy Business Alliance. I also presented on behalf of ORS at numerous solar and clean energy trade groups. I led the development of ORS's statewide energy policy report that was submitted to the Public Utilities Review Committee and that the ORS Executive Director presented to our congressional delegation in Washington, D.C. While at ORS, I was responsible for facilitating stakeholder engagement efforts following the passage of the Distributed Energy Resource Program Act of 2014, also known as Act 236. Specifically, I facilitated meetings and the subsequent settlement agreement on the new net metering programs that were developed in accordance with Act 236. I was also responsible for leading stakeholder discussions and settlement agreements that implemented the investor-owned utilities distributed energy resource programs. I testified on behalf of ORS in proceedings before this commission related to Act 236, including net energy metering and distributed energy resource programs. I have been an energy regulatory consultant since 2018, where I provide regulatory support to electric utilities throughout the United States. I have served in my current role with the company since August of 2019. In my current role, I assist Duke Energy Carolinas and Duke Energy Progress in its implementation of Act 62 related matters, including avoided cost, integrated resource planning, net metering, solar choice metering, and I facilitated stakeholder engagement activities and settlement discussions related to net metering and solar choice metering. I recently provided testimony to this commission in these matters.
Thank you, Ms. Ford. And please, could you specifically describe your involvement on behalf of the ORS in the Act 236 NEM settlement as approved by order number 2015-194?
Yes, sir. I actually have that order here, and I think it accurately describes my involvement on page 18. And that reads, quote, "Witness Ford provided testimony describing ORS's involvement in the proceeding, the net metering methodology presented in the settlement agreement, and support for the settlement agreement in general. Witness Ford testified regarding the manner in which ORS served as a facilitator and resolved issues among the 17 parties in the proceeding. Additionally, Witness Ford testified to the specifics of the settlement agreement, including the one-to-one rate provision and the ability of some customers to remain on a one-to-one rate through December 31st, 2025, the components of the methodology, the process by which under-recovered and over-recovered revenues are determined, and the timeline utilities have to file new net metering tariffs.
Thank you, Ms. Ford. Mr. Chairman, and based on Ms. Ford's prior roles with the ORS, her extensive knowledge of Act 236 and Act 62, her prior involvement in dockets related to these pieces of legislation, I propose to attend this witness as an expert in the field of NEM, EE, and DER.
Questions and objections?
Yes, Mr. Chairman, I have some board ire of Ms. Ford.
Please proceed with your voir dire.
And just for clarification, I'm sorry, the area was in NEM, DER,
And EE.
and it's probably easier if I come up there.
Yeah, sure.
And for my commissioners who are not attorneys, voir dire are questions about the witness's
witnesses.
expertise.
Beg the chair's indulgence just while I get situated. Good afternoon, Ms. Ford. My name is Ben Muschin. I'm an attorney with the Office of Regulatory Staff. I don't believe we've had the pleasure of working together before, so
We have
nice to
not.
meet you.
Nice to see you as well.
Ms. Ford, I want to talk with you a little bit about your background. First, I noticed that you did not include a CV or a resume with your testimony. Is there some reason why you did not provide that to the commission?
There's no reason.
And I also see from your rebuttal testimony that you work as a consultant for Duke. Is that correct?
That is correct.
Okay, and I was a little curious when you testified a minute ago. It sounded like you were describing yourself as an employee of Duke Energy. Are you an employee or are you a consultant?
I'm a consultant.
Okay, so then who do you actually work for?
There is a consulting agency that Duke contracts with, and that is my employer.
Okay, and what agency is that?
Zempleo,
Okay, and where is Zempleo based?
I believe California.
And what do you do in that role for Zempleo?
Well, they basically just handle the consultant process.
Okay.
I report directly to a Duke employee, Heather Shirley Smith.
Okay, so the only company that you work for is Duke?
No, I consult with other utilities as well.
Okay. And what is your position at Zempleo?
I'm a consultant.
That's your title?
I believe it may be officially contingent worker, but yes, it's a consultant.
Okay, it's a contingent worker, so you work on a contingency basis, is that
I do.
correct? Okay, are you working on a contingency basis in this case?
I work, yes, I mean, it's a contingent worker, so I'm not sure.
Mr. Chairman, if I may, I'd simply ask, I think he may want to clarify what he means by that term to make sure we're just not talking past each other.
Certainly. Is your compensation in this proceeding, or is your compensation from Duke contingent upon an outcome in this proceeding?
Oh, no, not at all.
Okay, any performance bonuses or any other type of compensation you would receive based on an outcome in this proceeding?
No, I charge a base hourly rate.
Okay. Other than the Office of Regulatory Staff, have you ever testified on anyone else's behalf other than Duke?
I have not, before this commission, no.
Before any other commission?
No, I've drafted testimony but not testified.
Okay. So how long have you done work for Duke in your role as a consultant?
As I stated, since 2019.
Okay. And where is your business office located?
I work from home, so it's at my home, but I do at times work out of the Duke office here in Columbia.
Okay. And I believe I had noticed that you had your business address on a LinkedIn profile, or maybe was identified as a Duke address. Would that be accurate or inaccurate?
I don't believe I have Duke address on my LinkedIn profile, no.
Okay. So I see from your testimony that you, and I believe Mr. Cooper indicated that you graduated from Lenore-Ryan University in 2002. Is that correct?
That's correct.
Okay. And you said your degree was in communications. Is that
Yes,
right?
sir.
Okay. So you've had no formal education in the areas of electric utility operations. Is that right?
I have. I've attended multiple classes through NARUC, the rates school. When I was at ORS, they sent me to multiple to classes. In addition, I would state that with 12 years in the utility industry, I have extensive experience. I was trained by people that had 30, 40, 50 years in the industry. As you can see through my background, I have worked on a lot. I've done a lot of analysis. I've done a lot of examinations of utility filings, of legislation, and as you are aware, there's multiple ways to be an expert. and one of those is through experience.
But when I say formal education, you have not received any education from an accredited university in the areas of electric utility operations.
I have not.
And none of an accredited educational institution on solar development or deployment,
Again, no.
utility finance.
No, my degree's in communications. That was also longer ago than I'd like to admit. And again, over 12 years in the utility industry, experience a lot of times outweighs education that you receive when you're 18 years old.
But no accredited academic background in energy efficiency programs,
Again, no.
demand side management programs,
Again, no.
DER,
No, sir.
legal analysis or statutory interpretation.
No, sir. I'm not an attorney.
You haven't gone to law school.
No, sir.
All right. And I looked at, it appears from your prior employment at Duke, or prior to your employment at Duke, you worked for Proactive MD, is that correct?
I did.
Okay, and tell me what you did there.
I served in two roles there. I began doing operations and continuous improvement. It's a healthcare company. And then moved into, actually it was a startup, and they moved me into over marketing and sales support.
Okay, and Proactive MD, that's the company that that markets acne cream and
No.
cosmetology things. Is that
No.
not correct?
No, it's a completely different
Okay,
company.
what does
That's
Proactive do?
Proactive. This is Proactive MD. It is a on-site healthcare company. They provide on-site benefits to employees.
Okay, so while you were there, your role was primarily related to marketing and communications. Is that right?
And I actually also did a significant portion of my time in operations, which dealt with compliance of medical regulations, complying with HIPAA, OSHA, and all the things that go along with healthcare.
Okay, but nothing related to solar facilities.
Not unless they had panels on the roof.
Okay, nothing related to utility operations.
No, sir, it's a healthcare company.
Okay, nothing related to energy efficiency.
Again, it's a healthcare company.
Nothing related to DSM.
No.
Nothing related to DER.
No.
And nothing related to legal analysis or statutory interpretation.
I actually did statutory interpretation in that role.
And
There are statutes related to healthcare, both state and federal, and being a healthcare facility and a provider, the company had to comply with those, and part of my role was to make sure that we did comply with those.
okay. But you had no legal training with respect to statutory interpretation or legal analysis. Is
No,
that
sir.
correct?
I have experience in it. And as you know, being in a regulatory position, as I believe even your own witnesses stated, you do look at statutes, you do look at all of the legislation, and you ensure that there's compliance with it. Obviously, I defer to our legal team for the legal component of it, but a significant portion of what you do as a regulatory analyst is looking at regulations, ensuring that you are complying with them, whether it be on the regulatory side or the utility side. And so there is analysis and an understanding of regulations.
Okay, but you would agree with me that doesn't give you qualifications to provide legal opinions, correct?
No, but I can provide my opinion to my understanding of the legislation.
Okay. Prior to your being employed at ORS, you also worked at the Budget Control Board as a field service representative, is that right?
I did.
And what did that involve?
It was the agency that administered the state health plan. It used to be Employee Insurance Program. It is now PEBA, Public Employee Benefit Authority, which does health insurance and retirement. And in that role, I went throughout the state and trained those who administered the state benefits, the health insurance, life insurance, disability. I also reviewed appeals and claims that were filed, looking at the state program, what the contractual obligations were under that, and whether or not, members should have claims denied, if they should receive disability. I had to look at legislation that applied to the health care that was being offered to state employees as well as federal health care regulations. And so it was an analyst and essentially a regulatory analyst type role, but on the healthcare side.
Okay, but is it safe to say that in that position you didn't do any work with solar facilities, utility operations, DER, DSM, legal analysis, legal opinions in any sort of structured way?
I think the regulatory analysis and looking at legislation did take place, but the others that relate to DER, no.
Mr. Chairman, I want to give my colleague ample time to ask these questions. I'm wondering the relevance of pointing to positions that she's held in prior jobs and titles that she's clearly established her training, her experience, her knowledge through her time with ORS and her work. I'm just wondering what the relevance is of these extensive questions on prior positions that she's had. I'll stipulate that any job she had in college is not relevant to her being an expert, but certainly I think she's shown her her experience, her training, and familiarity in conformance with South Carolina law as it relates to the relevant position she's held.
Mr. Chairman, first I would say that I believe it is relevant from the standpoint of, in order to be qualified as an expert, she has to be shown to have some special skill or education or experience with respect to her time at Proactive and with respect to her time at the Budget Control Board. That is relevant in a temporal standpoint because she was employed in those positions from a significant period of time between when she was at the Office of Regulatory Staff and when she became a consultant at Duke, at which time she has just acknowledged that she did no work relating to solar facilities or DER or DSM or any of those other matters. So in addition, as we had indicated in filing our motion to strike, Ms. Ford purports to state what we believe are legal conclusions. We'll address that at the appropriate time. However, feel like it's also important and necessary to lay the groundwork that she has not had any legal training or legal education in these positions.
Mr. Chairman, if I may.
Yes, you may.
Mr. Chairman, again, with my colleague, with all due respect, and I understand he was just talking off the top of his head, but he used the term special skill, and what he just provided to you is not in agreement with established South Carolina law. And I'm going to read to you from State v. Mueller, which is 425 SC 625. It's a 2019 decision. And let me state the trial court does not abuse its discretion in qualifying experts and allowing their testimony as long as the witnesses have acquired by study or practical experience such knowledge of the subject matter of their testimony as would enable them to give guidance and assistance to the jury in resolving the factual issue that is beyond the scope of the jury's good judgment and common knowledge. This same case also says that the qualification of an expert witness and the admissibility of an expert's testimony are matters largely within the trial court's discretion. It further explains that the party offering the expert must establish the witness has the necessary qualifications in terms that the witness has, in terms of knowledge, skill, experience, training, or education. I think that the key part of this that's maybe being overlooked is her knowledge, her experience. We're not asking her about solar panels in California. We're asking her about DSN, the NEM implementation of Act 236 in South Carolina. We're asking her about lost revenues in South Carolina in a South Carolina order that she is cited in, that she's discussed, that said she did all of those things. Those aren't her words. We can go look at the order that's published that describes what she did. That's what's relevant is her role. She has, unlike other witnesses who've been certified as experts, she actually participated in the generic docket for Solar Choice, and she participated and testified before this commission in the company Solar Choice docket. So I don't understand why. I understand that there's an allowance to voir dire the witness, but I also think we should show some degree of respect for Ms. Ford and her experience and what she's done before this commission on the topics that are South Carolina law. I'll stipulate she's not an expert in California, but she is an expert in South Carolina, and she's proven herself through experience on Act 236 and Act 62.
All right. Well, let me say a couple of things. With all due respect, the chair gets to decide who's qualified as an expert. It's me today. It could be my cousin, Commissioner Williams, tomorrow. I don't think Attorney Mustian is outside the rules in terms of asking questions to determine whether or not she actually can assist the commission in understanding issues that are potentially beyond our understanding. I'll also say that I recognize that voir dire is not something that of an expert witness, or even qualifying an expert witness is not something that the commission has done frequently since my time on the commission, and I honestly think that your questions in attempting to qualify her and your questions in attempting to, I guess, feel comfortable with whether or not she's an actual expert in what she's been offered helps the commission. And I appreciate it, and I think my fellow commissioners appreciate it. With that said, we definitely don't want to waste any time. So if you have a point or you want to move to disqualify her in a certain area, I would ask that you go there. I didn't mean to rush you, but if you're gonna, it sounds like you're building up to.
Well, that's. Can I beg the chair's indulgence for 1 minute? Mr. Chairman, if I could just respond, and I will limit my voir dire after this. Let me just respond to one thing that Mr. Cooper stated. He made the comment, as I recall, and Mr. Cooper, if I misquote you, please correct me, but that the rules do not require any kind of special knowledge. Mr. Chairman, I would point you to Rule 701 of the Rules of Evidence, which do apply to this commission. Which very specifically says if the witness is not testifying as an expert, the witness's testimony in the form of opinions or inferences is limited to those opinions or inferences which A, are rationally based on the perception of the witness, B, are helpful to a clear understanding of the witness's testimony or the determination of a fact and issue, and C, do not require special knowledge, skill, experience, or training. So, Mr. Chairman, I would say that it does require special knowledge, skill, education, or training in order to appear as an expert witness. With that said, Mr. Chairman, we would oppose Ms. Ford being qualified as a witness. I believe he had said in the areas of DER and EE, we would acquiesce to her being qualified as an expert in NEM. However, we also would object to any offering that she may have as to legal opinion in this matter, which we can address at the motion to strike if that's the chairman's will.
All right, I just want to make sure I got your objections. You object to Ms. Ford being qualified as an expert in the areas of DER and EE?
Yes, sir.
And is that it?
And to the extent that she is attempting to provide legal opinion.
Okay.
However, that's probably more appropriately addressed in the motion to strike.
Right. Okay. All right. So I appreciate your recitation of Rule 701. I would go further to the next rule, to 702, which states if scientific, technical, or otherwise specialized knowledge will assist the trier of fact to understand the evidence or to determine the fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. And I think I've heard enough regarding the witness's background at the Office of Regulatory Staff. Now, while I've never worked at the Office of Regulatory Staff, what I have observed is that the employees there who work in technical areas have deep knowledge and experience in various issues that come before the commission. Also note that the witness has been cited in I believe that was an order that she read from.
Yes, sir, Mr. Chairman.
In the areas where she's offering, or the party is offering her as an expert witness. Now, I do understand that the witness may not have an engineering background or a technical background. That being said, going through NARUC programs and other technical programs myself, there is opportunity to become knowledgeable in those areas without having the actual degree from an institution. With that said, I do find the witness qualified in, well, let me ask this. Let me be fair to my colleagues. Are there any questions from the commissioners regarding this witness's knowledge, background, or expertise, training in the areas of DER, EE? No. All right, so I found the witness qualified in the areas of DER and EE. And to the issue of providing statutory interpretation as a general practice, we don't, I don't qualify an expert in the area of statutory interpretation. She may give her opinion as to how she reads the statute, and we will take it for whatever it's worth.
Thank you, Mr. Chairman.
All right, thank you.
And Mr. Chairman, I'm sorry, so just to clarify, we had said NEM, EE, and DER, and I believe there was no objection to NEM, so were you clarifying that it's NEM, EE, and DER, all three?
Right, you're exactly right. So
Thank you, Mr.
the
Chairman.
objection was to DER and EE. I found her qualified in those areas because there was no objection to NEM. I accept your offer of the witness as an expert in that area.
Thank you, Mr. Chairman.
But as to statutory interpretation, to the extent that she offers expert opinion on the intent of the General Assembly, I am not allowing that. She can give her opinion of what she thinks, but not as to the intent of the General Assembly.
Thank you, Mr. Chairman. Ms. Ford, did you prepare or cause to be prepared 8 pages of rebuttal testimony that were pre-filed with the commission in this proceeding?
Yes, I did.
If I ask you the same questions that you were asked in your pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
Mr. Chairman, I would ask that Ms. Ford's pre-filed rebuttal testimony be entered in the record as if given orally from the stand.
Mr. Chairman, I'm sorry, Mr. Chairman, if I may, and I don't know at what point the appropriate time would be to address the motion to strike. As I had mentioned earlier, we had, instead of addressing that issue as a pre-hearing matter, we agreed to address it at the appropriate time.
Yes, sir, you can address it now.
And I certainly understand the commission's, or the chair's ruling previously, as we did state in the motion to strike, and I will not belabor the issue. However, we do believe that there are 2 portions of Ms. Ford's testimony that do constitute an admissible legal opinion. The first is on page 4, lines 15 through 17, where she attempts to testify about the meaning of South Carolina Code 584020I, when she states that the language of the statute exclusively addresses DER program costs. That is a interpretation as to the statute, not what the plain language states. And in addition, page 5, lines 16 through 18, where she attempts to opine on the legal meaning of the language in order number 2015-194 and 584020I, when she states that lost revenues in those contexts refers to revenues associated with providing the one-to-one retail rate credit. Mr. Chairman, ORS takes the position that these statements do not articulate any facts, but rather constitute legal opinion, which is inadmissible under South Carolina law, for instance, in Dawkins v. Field, and Green v. State, and for with respect to the other arguments we would refer to and rely upon our motion.
Attorney Cooper?
Thank you, Mr. Chairman, and I'll be brief. Mr. Chairman, is you stated earlier, to quote you, that you and the fellow commissioners can weigh and determine what weight to give any evidence submitted by a witness. And I'd further say that the concerns are much reduced in a situation like this, where the tribunal are a panel of experts, as opposed to if you had a jury of laypersons where there could be confusion. So this is a situation where we already have built-in safeguards. There's less of a concern. I would also point out that Ms. Ford has established her familiarity with the text, specifically on the lost revenues order 2015-194. That's the exact order that she cited in, and it talks about her extensive involvement with all aspects of this. Going back to her testimony on page 4, I would point out a couple of things. Ms. Ford is responding to witness Morgan. It was Mr. Morgan's own conclusion about the legislation that he and I talked about that she's responding to. She has produced the statute in full, and she is responding to and giving her opinion about Mr. Morgan's testimony. She's not testifying as to legislative intent. And so I think it's very clear that the commission can see that, can make its determination, and she's obviously allowed to rebut Mr. Morgan. Furthermore, there's the opportunity to cross Ms. Ford. I didn't strike Mr. Morgan's testimony. Rather, I asked him several questions to establish his ability to testify on this language. I asked him if he'd participated in the generic docket. He said no. I asked him if he'd participated in any solar choice tests. He said no. Those are all things that assist you as the trier of fact, I hope, with all due respect, I intended it to, in your decision as to how much to weight this testimony. So that's the whole purpose of this process. So I think there are the safeguards in place. Certainly there's, as you indicated, you make this decision, and there's the South Carolina law gives you broad discretion on these things. So with that, we would respectfully request that you deny the motion to strike.
Understood. Well, let me say a couple of things. This has been an issue throughout the course of this hearing, and I can understand the concern of a party's witness offering what would be considered a legal opinion or statutory interpretation. I haven't seen that in this hearing. What I've seen and heard are witnesses who are qualified as experts in their particular subject matter giving their expert opinion. I don't think, in my opinion, that doesn't arise to a legal opinion or speaking to the intent of the General Assembly as much as it is their opinion about the law. And to that end, I think the Commission can give that whatever weight we believe it deserves. So with that, your motion is denied.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Ms. Weed, I think I know where I was, but I'm going to repeat myself just in case for the record. So, Ms. Ford, did you, let's see, I think, okay. I think I'm back to, Mr. Chairman, I would ask that Ms. Ford's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
I'm sorry, state that again, sir.
Mr. Chairman, I would ask that Ms. Ford's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Ms. Ford's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Ms. Ford, would you please provide a summary of your testimony at this time?
Good afternoon, Chairman and members of the Commission. It is a pleasure to appear before you today. The purpose of my rebuttal testimony is to address important distinctions between lost revenues associated with the company's Distributed Energy Resource, or DER programs, and net lost revenues as provided for in the EEDSM mechanism. ORS witness Morgan takes a position that cost recovery of EEDSM net lost revenues is not in compliance with SC Code Section 584020I of Act 62. He neglects to acknowledge that this section exclusively addresses DER program cost related to the programs designed to jumpstart the installation of DER under Act 236. His testimony ignores the fact that the companies are not proposing to recover lost revenues associated with solar choice metering customers, as was done with the DER programs. Instead, the companies are requesting approval of an energy efficiency program that provides for the recovery of net income or net loss revenue as defined in SC Code Section 583720 and in the approved DSM-EE mechanisms. The recovery of DER program costs occur pursuant to Commission Order 2015-194, which provided a specific methodology for calculating the net estimated under-recovered lost revenue from net metering customers. In contrast, Commission Order numbers 2021-32 and 2021-33 approved the company's EEDSM mechanisms and permit the recovery of net lost revenues, which are defined as revenue losses due to new DSM or EE measures, net of fuel cost and non-fuel variable O&M expenses avoided at the time of the kilowatt-hour sales lost due to the DSM or EE measure. The EEDSM mechanisms permit recovery through the DSM-EE rider of up to 36 months of energy efficiency net loss revenues associated with the implementation of a DSM-EE program. Notably, such energy efficiency net loss revenues may only be recovered when there are quantifiable savings for all customers resulting from an EE program. Additionally, net loss revenues for energy efficiency and demand-side management offerings are associated with the EEDSM program rather than the source of the savings. The company's day-to-day implementation of these commission orders makes it clear that the net metering loss revenues recovered under DER programs are completely different than the net lost revenues the companies are permitted to recover under the EEDSM mechanism. Witness Morgan's testimony also ignores the critical distinctions between net metering lost revenues and energy efficiency net lost revenues. Specifically, the companies calculate net metering lost revenues using the total generator output, whereas energy efficiency net loss revenues only look at the reduction in consumption. There's a significant difference between 1, lost revenues based on net metering total generator output, and 2, net loss revenues based on reduced energy usage due to self-consumption, which the Commission has already found is, quote, equivalent to energy efficiency or demand-side management measures as a decrease to system load, end quote. Additionally, energy efficiency net loss revenues are adjusted for net found revenues, whereas there is no such adjustment with net metering lost revenues. Finally, net metering lost revenues are recoverable for as long as a customer receives the 1-to-1 retail rate credit, but energy efficiency net lost revenues are only recoverable for up to 36 months. In conclusion, the company's proposed program is consistent with the energy efficiency statute and the Commission-approved mechanisms, and the projected savings from the program means that all of the company's customers would save money through the program's implementation. As such, I believe the Commission should approve the program as outlined in the applications. This concludes my testimony summary.
Thank you, Ms. Ford. Mr. Chairman, the companies would next call Mr. Lon Huber. Good afternoon, Mr. Huber. Would you please state your name for the record?
Lon Huber.
And by whom are you employed and in what capacity?
Duke Energy Business Services as Vice President of Rate Design and Strategic Solutions.
And how long have you worked in the utility industry?
Approximately 14 years.
What is your educational background?
I hold a Bachelor of Science in Public Policy and Management and an MBA.
Okay. Have you previously held any roles that are relevant to your testimony today?
Yes, numerous. I began my career in the energy industry at a solar research institute at the University of Arizona. After that, I worked for a solar installation company, working a variety of different roles, primary being a policy governmental affairs staffer, but also was involved in sales and financing for that company. It was 50 people, so everybody does a little bit of everything, right? After that, I worked for a global solar energy manufacturer as a policy specialist. And then I jumped to the executive branch of Arizona, where I served as a consumer advocate, the lead staffer on electric issues at the Residential Utility Consumer Office. Following that, joined the consulting space for the utility industry, both in a smaller consulting firm and then a very large one, similar to E3, I would say. And in those roles, I provided expert witness testimony, strategy, analytics, pricing solutions to clients all across the country. My specialty was really for consumer advocates and commissions, given my former background at the Residential Utility Consumer Office. However, I also consulted for technology companies and utilities.
Thank you, Mr. Huber. Please describe your involvement with the company's solar choice metering tariffs that were approved by the Commission in dockets 2020-264E and 2020-265E.
Sure. I was very involved in the development of those solar choice metering tariffs, including designing the rate structures of the tariffs, negotiating with parties, trying to create that triple win outcome for all customers. And I provided testimony in the solar choice dockets explaining how the company leveraged best practices from the generic net metering docket to achieve the requirements found in Act 62.
Thank you, Mr. Huber. And can you elaborate more on your current responsibilities?
Sure. So in my role as Vice President of Rate Design and Strategic Solutions for Duke Energy, I'm responsible for overseeing the development, analysis, and implementation of pricing and rate design for all Duke jurisdictions. I'm tasked with leading strategies around innovation, strategic partnerships, development of new rate designs and product bundles in response to changing electric needs. And again, this is for all Duke's jurisdictions.
Thank you, Mr. Huber. Mr. Chairman, based on Mr. Huber's extensive experience in matters related to rate design and his intimate knowledge of the solar choice metering tariffs adopted by this commission, I propose to tender this witness as an expert in the fields of rate design and South Carolina net energy metering.
Any voir dire?
No objection, Mr. Chairman.
All right, the witness is qualified as an expert in the areas of rate design and South Carolina net energy metering.
Thank you, Mr. Chairman. Mr. Huber, did you prepare or cause to be prepared 11 pages of rebuttal testimony that were pre-filed with the commission in this proceeding?
Yes, I did.
And if I asked you the same questions that were asked in your pre-filed rebuttal testimony this afternoon, would your answers be the same?
Yes, they would.
Mr. Chairman, I would ask that Mr. Huber's pre-filed rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Chairman, this is Andrew Bateman with ORS. We do have two objections to Mr. Huber's pre-filed rebuttal testimony, and excuse me, sir, I want to make sure I'm not in the way of the cameras. Yeah,
I think
we can alternate. You want to alternate?
Yeah, if it works. Thank you. Thank you, Mr. Cooper. Mr. Chairman, we have two objections to two pieces of Mr. Huber's testimony. One of those objections is based on what we believe to be improper legal testimony. By way of background, I understand the chairman's ruling earlier, though I would point out something that I thought particularly interesting about this sentence is Mr. Huber uses the term precedent. The commission may recall Commissioner Caston and I had a discussion about the meaning of the term precedent in an oral argument about a week or two ago, and how it has significant connotations that I believe Mr. Huber himself doesn't even understand, which is why I think he is improperly, he's not qualified to make the statement in the sentence here. And for that reason, we would object to this sentence be included in his pre-filed rebuttal as improper legal testimony. And Mr. Chairman, I'm happy to discuss our objection based on the separate grounds on the other piece now, or I can wait till after your ruling, whichever you'd prefer. And Mr. Chairman, Mr. Cooper just made a good point. To be clear, this sentence, and it's in our pre-filed motion, but to make clear right now, it's on page 7, beginning at line, it looks to be line 2, maybe, Mr. Chairman. It begins with taken together, and it discusses the plain language of this commission's own precedent. And Commissioner,
read it for us.
Absolutely, yes, sir. Taken together, the plain language of this commission's own precedent makes clear that solar may function as an EE measure and that the solar choice tariffs were designed to take advantage of this flexibility in multiple contexts and programs. The case law that I couldn't recall in the oral argument a couple weeks ago is that it's a Concord Street Neighborhood Association's case, and it discusses the commission being an administrative body and its precedent not necessarily being binding and not necessarily being the same type of precedent that is issued by the Supreme Court. Now, I doubt Mr. Huber knew that context, and that's absolutely fair. Mr. Huber is not a legal expert, and that's exactly why we'd move to strike this sentence.
All right. You say you have another objection or another motion to strike?
May I ask you just a clarifying question, Mr. Chairman?
Mm-hmm.
Sorry. I didn't know whether it would be easier for me to respond on this one and we take each, or if you want, however.
It doesn't matter. Whatever works best for you. I'm flexible.
I'll just since we're on this quote, if you would, it just allow me to go ahead and respond. I think it'll make it move a little bit quicker. Respectfully, Mr. Chairman, I'd like to read you the full context of Mr. Huber's testimony instead of reading you one sentence. And so if you read the full context of his testimony, you'd start on page 6, and I would start at line 14. And it says, as for the solar choice dockets, the commission recognized from the beginning that the solar choice tariffs could serve as a platform to work in concert with additional clean energy and efficiency measures to the benefit of all customers in the company's service territories. And then you see a block quote. As for Act 62's broader, so this is not his, this is clear, this is not his language, this is a block quote. And it says, as for Act 62's broader goal of continuing the deployment of all DERs in South Carolina, the solar choice tariffs properly recognizing emerging technologies and the ability to contribute to reductions in the utility peak electrical demand and other drivers of electrical utility costs by also establishing a platform for customers to adopt other DERs in the future, including energy efficiency measures and battery storage. And then the reference, the site is provided right underneath that. It's order number 2021-390 at 42 and 2020-264E. So he's provided you the full quote. He's provided you the citation for the quote so you can see that these are your words. And he just says, taken together, the plain language of the commission's own precedent. He's not using that term in a legal sense. He's not using that term advisedly. He's using that term in its plain language of precedent, meaning the quote that I just read above. So again, I appreciate the distinction Mr. Bateman's making, but I think when you look at the full context of Mr. Huber's testimony, he gives you the quote. He's letting you know what he's letting you know exactly what statement the commission has made that he's following. So we think, again, there's little risk to creating confusion. And again, because this is a tribunal of experts, we think there are the safeguards.
Mr. Chairman, may I briefly respond?
Mm-hmm.
Thank you, Mr. Chairman. Mr. Chairman, as this commission knows, as knows from this proceeding, I appreciate context. So I appreciate Mr. Cooper putting that in context. However, I don't believe putting improper legal opinion in context makes it proper legal opinion. As a result, that it's clear here that Mr. Huber used the term precedent in the sense that people typically think about the term precedent. However, it has legal connotations beyond that, which I assume Mr. Huber was aware. And for that reason, despite the fact that it could be put in context, I believe it's improper legal testimony and would respectfully request that it be struck.
I'm going to deny your motion to strike, and I'll say this to you. Maybe I'm giving too much credit to lawyers and not enough credit to the witnesses, but someone who is not an attorney that doesn't come out and say, I'm giving a legal opinion as to the statutory intent of a particular statute, who may not even know the definition or context in using the word precedent, seems like ample cross-examination material. And so my hope would be that's what happens. But as to that sentence, I think the commission is capable of giving it whatever weight it deserves.
Thank you, Mr. Chairman.
Thank you for your legal argument. It's very sound.
Mr. Chairman, would you like me to move on to my second objection at this point?
Yes, sir.
All right. Mr. Chairman, this is an objection based on a slightly different ground than what we've been covering. This is the same page, Mr. Cooper, page 7, bottom of the page, beginning on line 21. Mr. Huber is presumably responding to Mr. Ori. However, in his response, he brings up an entire customer survey, which the company had not brought up until this point in time. Mr. Huber is absolutely correct that Mr. Hori casually mentioned customers because that's the focus of ORS, Mr. Chairman, is to look at the company's customers in the public interest. Mr. Huber took that as an excuse to bring out an entirely new subject matter, this survey. We had no meaningful opportunity to conduct discovery on this survey. We don't know what questions were asked. We don't know the response rate. There are all sorts of factors which may make this survey valuable or not valuable. The point is we just don't know. because it was a new piece of material that Mr. Huber brought up in his rebuttal. And for that reason, we respectfully request that line 21 on page 7 through line 9 on page 8 be struck from his testimony.
Response?
Yes, Mr. Chairman. Mr. Chairman, sorry. I respectfully, my friend Mr. Bateman, I don't think that witness Horry was using the word customer here and there because it just the word customer. And Mr. Huber is not responding just to a reference, a casual reference to customer. If you look at Mr. Horry's direct testimony, pages 22 through 23, Mr. Horry is talking about the adoption rates of customers in South Carolina. And he's talking about adoption rates of customers on large scale in South Carolina. And so Mr. Huber has a study that looks at and examines South Carolinians and 22,000 South Carolinians and what their behavior is, what their adoption rates may be. So I would say this is a direct response, and it's a response that's, when we heard Mr. Horry yesterday in live testimony, he talked about adoption rates, he talked about patterns, and he talked about what he projected adoption rates to be. So I think this is very appropriate. I won't rehash the grounds I've already given. I know the chairman already knows the law on this. I will say that, certainly Mr. Bateman can ask on cross-examine Mr. Huber whether he conducted the study. He can test Mr. Huber to see if he's familiar with the study. He can get other context as to why the study was created to see if it's a proper study to come in. But I don't think a motion to strike without hearing more, I would respectfully say is not, I would ask that you not approve the motion to strike.
Understood, but I don't know if that's attorney, what you responded to, I don't know if that's Attorney Bateman's concern. What I heard him saying is that they didn't have a meaningful, or he didn't have a meaningful opportunity to review the study. It was brought up in rebuttal, and they're here facing it now without an opportunity to at least review the study or assess the study. Is that am I tracking what you're saying?
Yes, sir. We had no opportunity to conduct discovery on it, or at least a meaningful opportunity to conduct discovery based on the short timelines in this proceeding. Mr. Horry did not bring it up in his direct because he didn't know about it. He didn't know about it until it came out in rebuttal.
So yeah, that would be my concern.
Mr. Chairman, respectfully, I would say that Mr. Horry still had the opportunity to offer rebuttal to Mr. Huber's rebuttal, and I'd say that Mr. Bateman still could ask him cross-examinations about the study and allow the commissioners to ask questions about the study, and then a decision could be made. I don't know that he would be waiving anything at this time to allow the witness to be asked questions to further develop information about the study, why it was conducted, how it was conducted, and establish the background context and any safeguards about the study.
I appreciate that. I'm going to grant your motion to strike on the new information brought up in rebuttal, the study.
Thank you, Mr. Chairman.
Mm-hmm.
Let's see, I suppose with that ruling, Mr. Chairman, I would ask that Mr. Huber's pre-filed rebuttal testimony, subject to the chair's ruling, be entered into the record as if given orally from the stand.
Mr. Huber's pre-filed rebuttal testimony, subject to the chair's granting the Office of Regulatory Staff's motion to strike testimony regarding the study. Leave that. Could you tell me the lines again?
Yes, sir. Page 7.
Page 7.
Line 21.
Line 21.
Through page 8.
Through page 8.
Line 9.
Line 9.
Mr. Chairman, may I ask one question? I know we've addressed this, but I just want to clarify, what was this study, so I know, was this provided in discovery to ORS?
Mr. Chairman, from my understanding, it was not. To the extent I'm mistaken, I'll let you know, but from my understanding, it was not.
Well, so what I understood you to say is that it was not because you did not have a meaningful opportunity to review the study. So,
And I believe that to be the truth.
if
Mr.
it
Chairman.
was, that would
It would
have
change
an
things.
impact on my ruling, obviously.
It was not. I've just heard and
Okay.
confirmed it was not. Yes, sir.
All right.
And I apologize if I would ask the indulgence. I understand for this configuration, I appreciate that ORS is over here. Mr. Bateman can confer. Would you give me just one moment to confer with my colleague, Mr. Welburn, just so we have the same
Sure.
opportunity? Since this is an important matter. Thank you, Mr. Chairman. I appreciate your indulgence. Mr. Chairman, thank you very much. Nothing further on that. We will move on.
So I understand you saying nothing further, but you confirmed that it was not, the study was not turned over. I don't want it to be an issue later.
Yeah, I don't think it is an issue, and I think
Okay.
we're,
All right.
we're ready to move forward.
Yes, sir. Thank
Mr.
you.
Chairman. I believe, Mr. Chairman, we were at, you were asking Mr. Bateman about a page number and confirming what was struck. Has that been addressed? And
Yes, sir.
Okay, so his pre-filed has been entered into the record at this point in time.
Subject to that motion to grant. Subject to granting the motion to strike, his pre-filed rebuttal testimony is entered into the record.
Thank you, Mr. Chairman. I appreciate that. Mr. Huber, did you also prepare a cause to be prepared one exhibit that was attached to your pre-filed rebuttal testimony?
Yes.
Do you have any changes to that exhibit at this time?
No, I do not.
Mr. Chairman, I would ask that Mr. Huber's one pre-filed rebuttal exhibit be entered into the next hearing exhibit.
Mr. Huber's pre-filed rebuttal exhibit will be marked and entered into the record as hearing exhibit number 14.
Thank you, Mr. Chairman. Mr. Huber, would you please provide a summary of your rebuttal testimony at this time?
Sure. Good afternoon, Chairman, Commissioners. The purpose of my rebuttal testimony is to respond to certain allegations in the direct testimony of ORS witness Horry and Morgan. I explain why, based on my understanding of Commission findings in the generic net metering docket and the solar choice dockets, that solar can serve as an EE measure. I also address witness Horry's request for the Commission to reject the use of the UCT test, utility cost test, as a primary cost test in the EE context. Specifically, I respond to witness Horry's assertion that solar PV cannot serve as an EE measure by citing the Commission's own order in the generic net metering docket, which expressly ordered that when evaluating consumption of behind-the-meter solar energy, that consumption shall be treated as energy efficiency or demand-side management resources. I also point to the testimony I provided in the solar choice dockets explaining how the companies leveraged the testimony and findings of the Commission in the generic docket to achieve the solar choice requirements found in Act 62. In approving those solar choice tariffs, the Commission expressly recognized that they could serve as a platform to work in concert with additional EE DSM measures to benefit all customers in the company's service territories. Those Commission-approved tariffs have been characterized by industry press as potentially a new standard in the DER space. Recognizing these facts, the companies permit some solar choice customers to participate in the program. This is appropriate because the program reduces consumption from the grid and can optimize customer consumption during peak periods and reduce the utility's peak demand use. The program and winter BYOT are complementary. Incentivizes customers to reduce their consumption and modify their usage patterns, resulting in cost-effective system load reductions to the benefit of all customers. Now, with respect to witness Horry's reliance on the TRC, it should be noted that the UCT test is the accepted commission-approved primary test. Aside from that fact, the TRC provides a limited lens and treats private investment from customers as a cost, which skews the result in such a dynamic market like rooftop solar, where there's a lot of loans and different lease combinations. I also disagree with witness Horry's estimation that solar PV adoption will be the same with the incentive under pre-solar choice tariffs. The solar choice tariffs include more complex rate designs that will require much more explanation and willingness from customers to understand the complexities. The complex rate designs may also cause potential customers to feel less certain about specific bill savings and how they will materialize. For that reason, the actual adoption of solar PV between pre-solar choice tariffs and solar choice tariffs is likely to be different, but very hard to model before we have actual customer experience. So simply put, the solar as EE program's upfront incentive is expected to be a major driver of adoption for rooftop solar customers on that have electric heat. An upfront incentive is generally more valuable than potential future bill savings because it's provided upfront, and therefore there's a psychological value there. There's a value from a net present value perspective. It reduces the amount of capital that would be needed to be financed for those households that have trouble accessing the capital markets there and debt market. There's no difficulty in predicting the dollar amount of the incentive that's received, and it can be an important marketing tool for the industry. So in closing, the program proposed in these proceedings treats customers' self-generation of solar energy as energy efficiency, just as the Commission recently found, and utilizes solar choice as a platform for which to launch additional EE programs, just as the Commission intended. This concludes my testimony summary.
Thank you. Ms. Ford, Mr. Huber, please answer any questions of council or the Commission.
All right, self-described clean energy interveners.
Yes, thank you, Mr. Chairman. This is Emma Clancy. Good afternoon, Mr. Huber and Ms. Ford. My name is Emma Clancy, and I represent the Clean Energy Interveners. I have a few questions for both of you, but I'd like to start with Mr. Huber, if that's all right. Can you hear me all right, Mr. Huber?
Yes.
Excellent. So there has been a lot of discussion in this hearing about how the proposed program is the first of its kind, but have other similar innovative programs been approved throughout the country?
Well, I mean, there's a lot of innovation that's happening in the space. I would say that the general trend in the industry is to go to a more integrated approach with all different types of customer sided technologies, and to start integrating them instead of having these separate silos. So to that effect, you've seen states like Arizona, I was a part of this, that say, hey, energy storage is in the EE program now. I think Hawaii has a similar approach with energy storage, right? And that is a new shift. And maybe some traditional energy efficiency folks might disagree with that, but it's a new technology that can provide a lot of benefits. There's a proposal in Massachusetts from a utility that is looking to combine energy efficiency and treat solar as energy efficiency, and just simply looking at where weatherization programs are going. I mean, it's a simple Google search, and you can see that there's a variety of different efforts, including from the federal government, to incorporate solar within the broader umbrella of weatherization. Colorado, Minnesota, they have programs that have solar as part of that bundle. So I would say that South Carolina, will be the recognized leader, but this is this is the trend that the entire industry is going toward. Somebody had to be the first to say solar hot water is energy efficiency, right? But this again is following a broader trend. This is, this will not be an outlier. I would say that I'm sure there'll be another state soon that goes down this route. And again, the market has shifted for photovoltaic technology. Costs have come down and so forth. And so I think, just metering has improved, software has improved, coordination of the different resources have improved. And so people, everyone, governments, utilities, they're seeing the potential of combining and bringing energy, bringing solar energy into the energy efficiency frameworks that they have.
Great. Thank you for that explanation. Now, is this program, as Mr. Horry states, a win for the company's shareholders and private solar companies, but not the company's customers?
I mean, I certainly don't see it that way. Anytime when you have pretty much a 90-10 split of benefits where all customers receive 90% of the benefits, company receives 10, that sounds like a pretty good deal to me. And a pretty fair split of those benefits. And again, there, as Witness Duff talked about, there's so many different safeguards and independent evaluations to ensure that everything is happening how it's designed. And we were extremely conservative. I mean, Witness Duff gave the long list. I might have a few others to add, but I mean, those were conservative approaches to this, to the numbers. And I think, we would see with actual customer experience, especially as customers, get in these programs, see the response and the interactions of these different technologies together to provide system benefits for all customers.
So to your point that this program will benefit all customers, I have a few specific questions about how the program was designed to do so. So just to start, how specifically does the BYOT program complement the Solar Choice program? Why are they bundled?
Yeah, so when you're looking at a customer load profile, especially over the year, the beauty of these two technologies is that you have solar that provides a good base layer of energy and, probably a small amount of that winter peak, very small, but then a substantial amount in the summer peak as right. And so you have the thermostat that targets that winter peak, and it can still provide other seasons, and if there's emergency conditions, but it's really focused on those winter peaks where solar isn't necessarily there. So you've got a really nice, full, holistic resource that's covering all the different seasons, and that's providing not only energy, but then capacity.
Thank you. And just specifically, how does actually reducing those two peaks on the system, how does that translate into reduced costs for ratepayers?
Sure. So when you have, especially when you have a state that's growing, like South Carolina, right, you have to build new infrastructure to meet, the growth that's occurring out there. And so that is transmission distribution investments, it's generation assets. These assets are typically built to serve some type of peak. It's just without widespread, long-term, cheap storage, we have to balance the grid in real time. And so I always like to give the example, and it's close to the time now of a Halloween store. And if a Halloween store has a parking lot, do you size that parking lot for the peak Halloween season, or are you sizing it for the year-round visitors to that Halloween store, right? And typically you're going to size it to your peak season. And it's very similar when you have this fixed infrastructure that the utility system has to meet real-time load, is that you've got to prepare for when there's extreme weather, high load conditions. And so those peak times really drive investment costs that all customers end up paying, right? And there's also just general energy. You need general energy to power the system as well. And so, you know, a combination of those, if you do it right and you target those peaks, you can save all customers money from avoiding future capital expenditure.
Thank you. And this may be related to the answer you just gave. I'm sure it is. But how does the proposed program enhance or build upon, more specifically, the time of use rates under the solar choice rate?
Yeah, and this, I think, gets back to that platform conversation where, right. You know, you're trying to add up all these things, you know, together to get ample response, engagement, and peak demand reduction, and so the hope is that customers respond to the price signals in the time of use rate, and we have critical peak pricing. So we'll be calling these events every year. Right, and that gives a customer an opportunity to save. Or if they don't respond, then they obviously have to be subject to that type of pricing. And so, you know, there's been a lot of talk about that rebound effect. It's like, I don't think anyone's looked at rebound effect on a time of use rate with critical peak pricing. I mean, a customer that would use substantially more energy, they're going to be contributing, you know, a lot, which then obviously lowers rates for other customers, right? But you know, these are all designed to send more accurate price signals to the customer and hopefully get some behavioral response to them. And again, we were conservative. We did not factor any of that in. Okay, so there's additional benefits there that we didn't incorporate, but you know, studies have shown, our pilots have shown that customers do respond to price signals, and so I'm excited to see how these particular customers respond, especially to those critical peak price signals.
And just as an aside, did you testify to these same benefits of combining the solar choice with this with BYOT in the solar choice dockets?
So this is, you know, I've heard some terms in this and around, I think it's, what was it, like end run or loophole, some of those terms, a Pepsi, Michael Jackson example, Michael Jackson ticket example, and I want to address that head on because I think this is actually a program that the commission should be very proud of, that the state should be very proud of. It is not double counting or double dipping by any means. The rate designs are specifically set up to make sure there's no near-term cost shift of embedded cost, okay? So that is very different than what we're talking about today, where we have found a segment of customers that could provide substantial system benefits if we can manage their load, okay, and if they engage in solar energy, and over a long period of time, 25 plus years. So this is a long-term marginal cost look at this particular customer segment. And this is not all solar choice customers. This is customers that have high load, high peak winter usage, right? That all electric with 25 years signed up. This is a different lens, a different look than rate design, which is short-term focused. It's, you know, it's a year. You're looking at it at basically a year. And rate design usually, almost always, doesn't take into account some long-term 25-year benefit stream, right? Those streams are usually more dynamic. You want to put those in completely separate programs. Rate design is more of ensuring you have you collect your embedded cost, you send appropriate price signals, right? That's what rate design is for, and it's usually not that dynamic. It's not like every year you're truing up and you're looking at it. How can you tweak it? It's much more it's not necessarily permanent, but it's just much more fixed than a program that you're designing based on market conditions and marginal costs that can always change, just like natural gas prices. Right? A year ago, we probably weren't talking about natural gas prices. Now the entire industry is talking about natural gas prices, and because they've shot up. So the EE programs look at in marginal costs 25, from long-term stream. That's very different than what we did with the rate designs.
Okay. But just to be clear, you didn't not mention that this incentive might come about, did you, in the solar dockets?
I recall mentioning them in verbally when I testified.
Great, thank you. Could this program help drive higher adoption of the BYOT program and other cost-effective EE programs?
Oh, absolutely. I think that's one of the features of this. It raises the profile of BYOT, and so I think it could certainly be a driver, and I think it just, as I said before, brings a more holistic energy management approach to a household, instead of just saying, hey, we're going to slap on panels to your roof and just be done with it. You don't have to worry about, exporting. You don't have to worry about managing your load. That is in the past. This is a completely new paradigm, and I'm really excited about it. And that's why we've gotten a lot of positive press around this. I was invited recently, a few weeks ago, to speak to the Maine, a commission-led process in Maine about this. This to me solves all these old debates about rooftop solar, which is probably, frankly, why some people aren't crazy about it. There's a lot of money in controversy. There's a lot of consulting money and trying in these fights every 2 years, every 3 years. So people aren't going to be, not everyone's going to be happy that this could actually solve these big net metering wars.
And do you expect the cost effectiveness scores for these Smart Saver solar programs to improve over time?
Yeah, I certainly, I would think so, just because we're going to be able to get a lot of real world learning, so then we can do some fine tuning of these programs. We can look at the data and see where we need to make adjustments. Do we need to create more of a digital experience for a customer to help them manage their usage? How are communications and notifications sent out to customers, right? I think there's a lot of fine tuning that from programmatically. Now, where, as I mentioned before, fossil fuel prices go and other market dynamics go, that's a different story. And I think in general, technology costs, over the long run will continue to go down as well. But I do feel that getting that real world experience will help us draw out further benefits.
Great, thank you. Well, just changing gears slightly, I had a couple specific questions about the incentive. And it sounds, based on your experience in rate design, do you expect the incentive to attract customers who might not otherwise have invested in rooftop solar?
Oh, definitely. With this all electric rate, these rates are lower compensation than RS rates. The paybacks are pretty dramatic, deep into the teens, maybe somewhere around 18 years. That's pretty significant. And so I do think that the incentive will drive adoption for sure. I've seen it when I've worked in the solar industry, how incentives go a long way in just the psychology of a customer, seeing that, that bit of capital help them offset the upfront costs, and a lot of times with the federal tax credit, they have to wait, or there's a timing mismatch there, where this incentive is more immediate and can help. So I think it's going to be a big factor.
Great. And relatedly, you raised a separate interesting point in your rebuttal testimony about the incentive. Could you elaborate on the statement? I'll read it to you, but it's on page 10, lines 5 through 7. You say that these more complex rate designs will require more explanation and a willingness on the part of the customers to understand these complexities.
Yeah, I mean, this is something that I've certainly learned, especially with, with just sitting at the kitchen table with customers, that this is complex stuff. And now we've, it's pretty simple under the old paradigm, even then it's sometimes complex with the customer of, hey, this is a relatively flat volumetric rate, you're going to be offsetting it. But now we've introduced so many different aspects. We have a minimum bill now. So you're going to have to explain to a customer the minimum bill and the fact that they might not ever see that minimum bill unless it's maybe the spring, or they might see it every month depending on their system size to load. Or it might, if their kids go to college, they might all of a sudden see that because their load goes down, right? And then you've got the time of use elements, which it takes some explaining. Then you've got critical peak pricing. Then you've got non-bypassables, right? It's starting to add up. And then you've got the whole the whole thing on the TOU netting, which I won't even get into. So that is a lot of complexity compared to today, where, hey, you've got a flat volumetric rate, slap the panels on, don't worry about it. And so I just know it's going to take a lot more, and already a pretty lengthy sales process.
Okay. And were you involved in the initial discussions where the signatories to the MOU began to frame the design of these programs?
Yes, I was.
And can you remind me around when those discussions began and when the design was taken to the collaborative?
I think actually witness Ford would be a better witness on that for those dates.
Well, welcome. Please jump in, Ms. Ford.
Thank you. Can you hear me, Ms. Clancy?
Yes.
Okay, great. So after the passage of Act 62, the companies were approached by interested stakeholders, specifically Vote Solar, to discuss ways that the parties could come together, similar to what we did during Act 236. We had during Act 236 a wonderful stakeholder engagement process. We had parties of very differing opinions, but the parties all came together, and it was facilitated by ORS. In fact, I was the facilitator of that. Came together to come up with a comprehensive solution to, at the time, Act 236 and net metering and what that would look like for South Carolina. And so Vote Solar approached the companies looking to do something very similar with the passage of Act 62. And Act 62, as I'm sure you're aware, had certain provisions to look at, to open a generic docket and look at the existing net metering programs, the value of the generation, future net metering programs, which ultimately became the Solar Choice. And so the companies pulled together interested stakeholders initially from that kind of original Act 236 group. And there was ORS, of course, the companies, Dominion Energy South Carolina, clean energy advocates like yourself, solar developers, and so we started just discussing how can we look at Act 62 and try to move South Carolina forward in a similar fashion as to what we did under Act 236. So the initial, we had kind of a brainstorming session, January 10th of 2020. That was a smaller group, so I don't have specifically. I know ORS, Duke Energy, Carolina's Duke Energy Progress, Dominion Energy South Carolina, Vote Solar, and I believe the Southern Environmental Law Center all had representatives, just kind of looking at what are our pathways forward. And out of that meeting, the group decided that a stakeholder engagement process similar to Act 236 would be ideal. As I mentioned under Act 236, ORS was the facilitator for that. In this process, Duke took the lead on that. ORS showed interest in being a participant, but not the facilitator. And so we had our initial stakeholder meeting on March the 12th of 2020. And I know there's been discussion about different stakeholder meetings. So I want to be clear that these are distinct and different from the energy efficiency and DSM collaborative meetings that have been discussed. That is a different group. It's a broader group. That is a well-established stakeholder group that's been in place for years. In fact, when I was at ORS, I participated in those on behalf of ORS to show you, how far back they go. And so this was a different group. This was to look at Act 62, net metering, and the future for South Carolina. So as I mentioned, the first meeting was held March 12th, 2020. It had representatives from the utilities, also low-income advocacy groups. I know that Chamber of Commerce, ORS. It was a broad group that was involved. In that meeting, we talked through Act 62. What does it require? What are some ideas? Here are some different elements of Act 62, and we talked through just differing opinions, very high level. From that, we had a second stakeholder meeting. Again, this was facilitated by Duke, and I was the lead facilitator there. And that was on April 23rd of 2020. The same groups were invited and participated. And in this meeting, we started to narrow some of the discussion. What could a new, net metering, solar choice metering tariff look like? What are some elements that are innovative, but also, help fulfill all the goals? And then the concept of looking at energy efficiency, solar, net metering, solar choice metering was presented. It was very high level. Just these are some concepts. There are also concepts of battery storage, recognizing that that's a growing technology, and how can we incorporate all of this in our pathway forward. From that meeting, some of the stakeholders reached out to the companies and started working more closely on getting into the nitty-gritty of concepts that came from that meeting. And so there were discussions that were going on with a lot of different stakeholder groups. And then I'm looking at my notes. Let's see, we had meetings with the groups. That large stakeholder meeting was in April of 2020. We had meetings with other groups throughout the spring and into the summer. Let's see. We had a lot of meetings. And then I would say late August, early September is when it really started to come together, looking at the components of, as Mr. Huber mentioned, solar choice metering, having a time of use tariff, having critical peak pricing, looking at potentially a minimum bill, a grid access fee, what would the netting intervals be, but also looking at this soon to, ultimately to be proposed energy efficiency program and looking at an incentive. And so we had meetings there. On September 10th, we actually had a meeting with ORS talking through these high-level concepts, mentioned the 36-cent incentive, and looked at, the solar choice tariffs that would be proposed. Ultimately, a settlement agreement, the MOU, was signed on September 16th of 2020. And at that moment, the 36-cent incentive had been thrown out there, but the program was still extremely conceptual, the energy efficiency program. So that was September 16th. We made a filing with the commission on September 21st. It was in the solar choice metering docket, and I cannot remember if we did it in the generic docket as well. But I believe it was just in the solar choice metering, and it outlined all the components of that MOU, including that incentive. Duke then initiated another stakeholder meeting with the large group. It included all the folks that I had mentioned before, ORS, all the other interveners, and also North Carolina public staff joined that call. And that was on September 23rd, 2020. We walked through the MOU, and then in November, since the settlement was signed in September, once the parameters were kind of conceptualized, then it went to the collaborative, that meeting occurs every 2 months. So the next collaborative meeting was in November. This was all presented to the collaborative. The group talked through, in developing this program, here are the concepts, but how do we actually do it? Really, let's work through it. And that's the goal of the collaborative. is to, toss ideas around, share data, share concerns, work through it. And so November, January, and then I believe even in March and then May collaboratives, this was discussed to solicit feedback, to truly develop the program, take it from conceptual to what we subsequently filed. And so I know that was a long answer to what might have been a quick question, but I do think it's important. There's been a lot of confusion. We talk about stakeholder in so many different ways. And I just wanted to clearly delineate there was a Act 62 stakeholder group, and then it was taken to the DSMEE stakeholder group, which is how it typically flows. We take ideas to the stakeholder, the DSMEE collaborative, to solicit feedback to hopefully, gain alignment where we aren't in heavily contested proceedings.
Right. So did you say the first collaborative meeting this program was taken to was November 2020?
The first DSMEE collaborative, correct.
EE collaborative. So if a member of the collaborative, like ORS had said, they absolutely could not support this program or the incentive, would you have taken that information back to the stipulating parties and continued those discussions at that time?
I would think that we would. That's one of the main goals of the collaborative, is to work through programs as they're being developed, to seek input from collaborative members, which, many of them are fields, experts in the field of energy efficiency and solar development and batteries and all the components of this. And so we look to get that feedback at the time. And again, to hopefully avoid, down the road, things being heavily contested, and as we were going through, we could have developed it and potentially made shifts and modifications.
Thank you. I have a couple questions for you, Ms. Ford. I believe you say this, but did you used to work for the Office of Regulatory Staff?
I did.
And did you hear witness lawyers' testimony on Tuesday suggesting that it wasn't ORS's role to provide any input on program design until a program had been filed with the commission?
Mr. Chairman, I would just object as a mischaracterization of Mr. Lawyer's testimony.
I'm happy to rephrase the question.
Mr. Chairman, I would also object. This question calls for speculation. Ms. Ford has not worked at the Office of Regulatory Staff for some time. She does not know the current policies of the Office of Regulatory Staff, and has no basis upon which she can testify to this matter.
I'm not asking Ms. Ford to speculate. I'm asking her about her own experience and her personal knowledge relating to these matters and to her experience at ORS.
Mr. Chairman, to that regard, I would say that it is, number one, irrelevant, because her experience with the Office of Regulatory Staff several years ago is irrelevant to the current procedures and policies of the Office of Regulatory Staff. I would also suggest that it is, whatever probative value this may have, highly outweighs backwards. You know what I'm saying? On that
It's more
basis.
prejudicial than probative.
Thank you.
At least that's your argument. Yes, sir.
Mr. Chairman, I'll be brief. I think rather than the council testifying as to whether the practices have changed or not, they would have an opportunity to hear Ms. Ford's answer. If Ms. Ford's experience or what she suggests about her role at the time of the commission is the ORS is different from their understanding today, if they want to question her and ask her if she realizes there's been a change in direction, a change in policy, they're welcome to do that. That would be the purpose of their cross, and they have not, we've not gotten to them yet to ask cross, Mr. Chairman.
Mr. Chairman, simply because cross is available does not make the question appropriate for asking. The question that she has posed is inappropriate, and it is certainly permissible to object for a question that calls for irrelevant and speculative information.
Again, Mr. Chairman, I would just state that I'm asking what Ms. Ford's personal experience was. ORS witnesses, put brought these, practices into the dialogue with their testimony, and not calling for any speculation or just simply asking about her personal experience and expertise.
Yeah, Mr. Chairman, I would say that Ms. Ford could talk about, and I think she's only being asked to talk about what she understood her role to be when she was at ORS. And so I think she's not being asked to speculate about what the role is today or what Mr. Lawyer said about the role today. I think she's just being asked to give her account as to what her understanding was, because in that order, that the commission's order from the DSM approving that settlement from Act 236, that order specifically talks about her role at ORS, her role as a facilitator, her role to, I can't remember what else it said, but it was something about facilitator and working out differences. And so I think it would be relevant to ask her, since that's in the order, that order is part of the discussion, to ask her about that.
Thank you, counsel, for your argument. So I'm going to sustain the objection to the extent that counsel, in my opinion, attempted to solicit some level of comparison between Mr. Lawyer's position regarding, or ORS's position regarding collaboratives versus Ms. Ford's. If Ms. Ford wants to give the commission her experience, then the best way to do that is simply to ask her about her experience. Now is a good time for a break. We're in recess until 5:15. 4:15, excuse me.
Mr. Chairman, very
One has left the hearing room. Ms. Clancy, let's go back on the record. Well, we're on the record. Let's go back on the live stream. Ms. Clancy, if that was your last question, I would like for you to finish your examination so you could go with your family on your trip.
Thank you, and I'm sorry for any confusion. Yeah, I did just want, based on, thank you for your explanation, Mr. Chairman, and I did just want to ask one more question. During your experience at ORS, Ms. Ford, did you work with utilities to provide feedback on any programs, or did you wait to provide input until a program was filed?
When I was at ORS, we oftentimes would provide feedback in advance of a filing being made.
Great. Thank you so much, Mr. Huber and Ms. Ford. I appreciate your time, and thank you, Mr. Chairman, for accommodating my conflict. I do appreciate it.
No problem. Enjoy your trip. We're in recess until 4:15. Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're in dockets number 2021-143E and 2021-144E. Present in the hearing room, we have Commissioners J. Williams, C. Williams, Powers, Belzer, and joining us virtually, we have Commissioners Caston and Thomas. Before we took afternoon recess, we were on the self-described clean energy interveners cross-examination of the panel. I will now move to the Solar Energy Industries Association.
Thank you, Mr. Chairman. Good afternoon, Ms. Ford, Mr. Huber. I don't believe I've had a chance to talk with either of y'all previously. I certainly witnessed your testimony in the generic docket and the Duke tariff docket last year, or over the last year. So pleasure to meet y'all. Ms. Ford, I had a couple of questions for you, but Ms. Clancy ably covered them. So I promise that I'm not ignoring you here, but I don't want to retread ground that's already been covered. So I'm going to focus my questions to Mr. Huber. Mr. Huber, just two very high-level questions to start, some of which was covered by Ms. Clancy, but I just want to frame it in a slightly different way. In this proceeding, are we talking about solar PV as EE or solar PV plus smart thermostat as EE? And is there a difference?
So what we're talking about is an energy efficiency program offering where the self-consumption of the solar is treated as EE and where the thermostat is treated as DR, demand response.
Okay, and I guess what's the difference?
The difference between energy efficiency and DR's energy efficiency is really about volume, like kilowatt hours energy, where demand response is typically a capacity. There's not very many kilowatt hours or energy related to that. So energy efficiency can still hit on peak, but DR is specifically focused on those peaks, and usually for a limited amount of time, maybe 2-hour events, 3-hour events, every so often, where typically energy efficiency is there much more frequently.
Understood. And then second high-level question, witness Horry testified that he did not see the synergy between solar PV and winter BYOT. Can you tell us why having rooftop solar customers specifically involved in adopting smart thermostats would be helpful for South Carolina?
Sure. Yeah. There's a lot there. I'll try not to be too long. So, one of the key things to keep in mind is just where is the industry headed? The industry is headed toward decarbonization. Okay. In order to cost effectively decarbonize, you have to take care of your peaks, your peak demand. And you have to meet that peak demand through clean resources. Otherwise, you have two systems, a sort of legacy infrastructure system and then a clean energy infrastructure system. That's expensive to have two systems, right? So the beauty with this is that you're using that thermostat and that solar to try to get as much clean energy coverage as you can during the peaks. And so, to the extent that solar's there, and remember, this is still, relatively in the first few chapters of solar technology. You see technologies where you integrate battery storage right behind the panel, the solar panel and so forth. And so, there's more technology coming down the line, but the general gist is you want to cover your peaks with as much clean energy as possible. You want to drop those peaks as well, right? It's all sort of tied together. And so that's one important element. The other important element is the fact that you want to have that synergy between the two, where if things change, you have some dispatchability, and you can address that with the thermostat, and you can make sure that those peaks are covered, or there's if there's an emergency, you can get further demand response. So there's that angle as well, of ensuring that the benefits are there, as well as that increased clean energy coverage during those peak times. So that's my start at least.
Thanks, and I think I'll cover a little bit more of those aspects in great detail. I just wanted to start with those high-level questions. So I'm going to hit three topics with regards to your rebuttal testimony. First, the significance of the 25-year term in this proposal. Second, the national reaction to the settlement that this program comes out of. And three, the future of the grid, which I think you talked about a little bit there. So first, the significance of the 25-year term. What is the primary problem that Smart Saver Solar is solving for? And that was a lot of S's.
Well, I mean, I think with the small, the smart, oh boy, Smart Saver Solar program is trying to solve it's trying to reduce use of the grid and peak demand of the grid to avoid future investments that all customers have to pay.
Right, and specifically winter peaks, correct?
It's winter peaks, but it's also energy throughout the year, and to the extent there's a summer peak.
And this is a long-term problem. This is not something that's going to go away.
Yeah, I mean, typically, especially when you're in a growing state, this is a long-term, problem that you're trying to solve. So you have, a lot of programs that all try to angle at this and to get adoption and to do as much as you can to avoid, as much of that fixed infrastructure as you can.
And that justifies the 25-year commitment that a Smart Saver Solar customer is being asked to make, correct?
Yeah, I mean, infrastructure isn't, built overnight. It's not avoided overnight. And so you need that long-term commitment.
Right. And a shorter commitment would reduce the level of incentive that the companies could justify.
I would have to look at that, but most likely.
Okay. And I guess the other way of asking that is the long-term commitment has value to the utility.
It has value to our customers, absolutely, in the sense that it's not just, hey, here's your upfront incentive, and now you only have to be here for a few years, and you can leave. It shows there's a permanence there to be able to really address those system peaks and to have that system performing for the entirety of its manufactured life.
That's exactly my understanding. Let's talk about the clawback provisions in the program. The clawback provision makes it more likely that a customer will perform its obligations under the program, correct?
Correct.
And that ensures that utility will recognize the value of the program.
Yeah, it's to ensure that the costs and the benefits are realized, right? The benefits are realized, costs are managed. Exactly.
And the risk of non-performance is paid by the customer if they opt out of the winter peak events.
Correct.
And in your extensive experience in the utility industry, have you ever seen an EE program with a 25-year performance obligation?
I don't believe so. But that doesn't mean that there aren't. And yeah.
No, and it just the time frame coupled with the clawback provisions gives you comfort that the non-participating ratepayers are going to get the performance from the participants in this program, correct?
Correct.
Okay. And how would you rate the risk that the ratepayers won't get what they're paying for?
And witness stuff, I think, covered this better than I could, but I think the risk is very, very low, especially given how conservative we were in the assumptions. I mean, there's a whole list of areas that we were conservative, and we provided all different types of cost effectiveness tests to provide other looks, and passing the RIM test in my book is a big deal.
And so, if the ORS position prevailed and the commission rejected this program, that would not affect Duke's bottom line in this, correct?
No.
Okay. And based on witness Duff's testimony, Duke expects to see significantly fewer solar choice installations outside of this program, correct?
Correct.
So if Duke was pursuing its pure financial interest, it might view the solar industry as a competitor and be rooting for this to fail.
Mr. Chairman, this is Andrew Bateman with ORS. Mr. Huber's stated purpose in his testimony is to respond to certain allegations in the direct testimony of ORS witnesses Ori and Morgan. Excuse me, I keep standing in front of the camera. I appreciate this cross, so I believe it really would have been more appropriate maybe for witness Duff or another company witness. I don't believe witness Huber is the appropriate witness to ask these questions of, and would respectfully object.
Response?
Your Honor, I think he's qualified to answer the questions. He's been qualified as an expert in, I believe, didn't write down exactly what he's been qualified on, but I think this is within his purview.
So just so I understand your objection, you're objecting to the fact that the stated purpose of his pre-filed rebuttal testimony is limited or exclusive to those areas as opposed to the question that the lawyer just asked, Mr. Kirkendall?
Yes, sir. I would object based on the fact that the stated purpose in witness Huber's testimony is, I read it a second ago, to respond to witness Ori and witness Morgan, and counsel Kirkendall has consistently asked questions far outside that scope. I believe they were really more appropriate for another company witness, not witness Huber.
Right. Well, the thing is, I just heard him say that he was unable to answer the question. It would have been better for witness Duff to answer. So he didn't provide an answer.
Well, I believe, Mr. Chairman, he said that and then did provide an answer subsequent to that. But that is essentially my point, Mr. Chairman. These questions are better served for another witness.
Okay. All right. Mr. Kirkendall, I'll give you a little bit of leeway, but the objection has been raised and noted. I'll give you a little leeway, but try to focus on the purpose of this witness's testimony as opposed to matters outside of that scope.
I understand. Thank you, Mr. Chairman. I guess some of the question is, why does Duke want this program to succeed, Mr. Huber?
Well, there's a variety of reasons. One, we just think it's the right thing to do for all customers. We think it responds to customer evolving customer preferences and evolving customer expectations, that there's technology that the utility offers to help them manage their costs, manage their consumption, and it is in line with where Duke Energy wants to go, which is a decarbonized future. We have goals around decarbonization, and so if we can offer something that's good for all customers, then also good for the participants, and these participants, these direct participating customers, can help us meet goals and provide, again, those benefits to the whole customer base. It's like I sort of mentioned before, it's a win-win-win, right? Why wouldn't I want a program like this? I guess maybe would be the other way to think about it. So I think it hits. It's and I think the term was used. I mean, this is apple pie type of stuff where you have such a great outcome for all parties.
Thank you, Mr. Huber. I'll move on to the second point I wanted to kind of explore with you, which is the national reaction to the settlement. I think in answers to some of the cross that Ms. Clancy raised a little bit earlier, you hinted at the national reaction. Prior to your current position at Duke Energy, you were involved in a number of net metering, correct?
Oh yeah, across the country, literally from Hawaii to Maine.
Wow. And can you describe the adversarial nature that exists between solar companies and utilities in your experience?
It could be very tense, and you could see television ads being run. There was just protracted battles that would last many, many years. And then even then, you think you would reach a resolution, and then something would happen, and so this has just been an ongoing saga for the industry in states across the country trying to figure this out, because as we all see, these are all complex issues, right? And there's arguments on both sides, but I would say throughout my career, I've tried to create these win-win outcomes. I've been consistent on that, even though I knew that I might make myself be out of a job or out of a whole stream of consulting, still, I really think this is as close as you can get to resolving the issue. I haven't seen any other state that has come close. There's an article in Utility Dive about how California could actually be looking to South Carolina to solve. They've got a big solar war happening right now, right? So that might scare some in California, but this is a comprehensive approach on through the entire package, the platform of solar choice, and then recognizing that there's a subset of customers with electric heating that can provide a substantial amount of value if you can encourage adoption along with the long-term commitment to the smart thermostat.
And that may answer this next question I had for you, which is, would you say the settlement that this comes out of is unique or paradigm changing?
I would agree with that. I think that's why I've been asked to speak on so many webinars and to different parties, all looking at how they could potentially adopt something like this that's holistic, that doesn't look at technologies in their own little silos and has, you have this one program over there, this other program over here, and it starts with that platform, getting those rate designs right to collect that embedded costs, and then we're also in this proceeding then looking, hey, are there certain long-term value streams we can capture? and what mix of technologies can we use to capture those for all customers. So I think it's a game changer. I really do.
And when you discuss the settlement in those webinars or conferences, you discuss the design, the combination of the solar choice dockets with the Smart Saver Solar concept, right?
Yeah, I typically go through and say, the first stage is getting the pricing right to make sure there's no near-term cost shift. And I go through, hey, there's a minimum bill, there's non-bypassables, there's TOU netting, right? And then I say, then for certain customers, there's a solar plus opportunity. Basically, where you're looking at self-consumption and then pairing it with a very synergistic technology to maximize benefits.
And what are your observations of how the South Carolina net metering settlement is viewed by utilities, regulators, and advocates that you've spoken with about it?
For the most part, I've witnessed widespread support. There's some on the I would say environmental side, maybe sort of on the far end of that spectrum that would probably say it's too far. It reduces the value proposition of solar too much. It doesn't include as many benefits as it should. That's sort of the main thrust of that, from what I've heard from parties that are against it.
Okay. And there have been some questions to other witnesses in this proceeding about whether similar proposals exist in other states. Do you have any insight into whether those exist and why or why not?
Mr. Chairman, this is Andrew Bateman once again. It's happened a number of times since I last spoke. I would just respectfully request that Mr. Kirkendall contain the questions of Mr. Huber to Mr. Huber's rebuttal testimony. Thank you, Mr. Chairman.
Mr. Chairman, I'd first suggest that this is not Mr. Bateman's witness. If the sponsoring attorney wants to object to my line of questioning, I'm happy to respond to that. But I'm not sure what grounds Mr. Bateman has to object to this if his own counsel is not objecting to it. And secondly, I think this is, certainly questions that have been asked of other witnesses, information that has come up that wasn't necessarily in their testimony that Mr. Huber may or may not have relevant testimony to give about.
Mr. Chairman, as far as I didn't weigh in the last time, I guess this is an awkward arrangement of keeping parties together. The reason why I did not object is my understanding of the law is that a party on cross-examination has broader discretion and can ask questions that are reasonably intended to lead to admissible or helpful discovery. And so my understanding is that I didn't object because I think the cross-examining party has a little more freedom to ask these questions and explore topics. I just would say that I think once that question's asked, I think we've seen from a number of witnesses, whether it's witness Horry or others, that once a question's asked, these witnesses are going to go and tell you their full experience, and they're going to tell you what all they see. So they have an opportunity to fully answer a question. That happened with my questioning of witnesses as well, and that's just part of how this process works. We can't limit them to just a question asked. We have to give them the opportunity to fully and fairly respond.
Mr. Chairman, if I may respond. Mm-hmm. My objection is not intended, honestly, to limit the response of witness Huber. It's rather intended to respectfully request, and the chairman certainly has the discretion to do this, that the questions asked of witness Huber be at least tangentially related to witness Huber's rebuttal testimony. Many of the questions thus far asked of witness Huber are so far afield of witness Huber's rebuttal testimony that they honestly have no bearing to witness Huber's rebuttal testimony, aside from the fact that he sat in this room when other folks testified. Now, the chairman certainly has the discretion, and I absolutely would defer to you, but for that reason, I would raise my objection.
Mm-hmm. All right, well, so refresh my memory. Whose witness is this? Is this,
This is the company's witness, my witness.
oh, I know that part, but,
Yes.
the Office of Regulatory Staff, is this your witness or Attorney Mustin's?
Is my witness, Mr.
Okay,
Chairman.
I was a little confused by that. So Attorney Kirkendall, Attorney Bateman is the appropriate counsel to raise the objection. Regarding the objection he raised, I think is a pretty simple objection based on how hearings like the ones that occur before the commission, you have pre-filed testimony. The witness usually states, maybe all the time, the purpose of the testimony. And usually the questions are related to the purpose of the testimony. That doesn't limit the witness's response, but I think they try to keep things moving so that we won't waste time here. I don't think it's a bad idea to ask questions that are relevant or germane to the purpose of the witness's testimony. Attorney Kirkendall, I thought we had a pretty good understanding of that. Is there something I'm missing? I don't want to limit your cross-examination, but it does seem
No,
to be.
Mr. Chairman, this was merely that in previous testimony that Mr. Huber had given, he had talked about his experience talking about this settlement in different jurisdictions with other jurisdictions, and connecting that with the previous direct and rebuttal testimony that's been given in this proceeding about whether there are similar proposals in other states or not in other states, and whether he had any insight on that. And that was just my question. I think it's something he's qualified to answer. I think it's been brought up in this proceeding, and I think if he can answer it, he should be allowed to.
Okay. All right, I'm going to sustain the objection. Please continue.
Thank you, Mr. Chairman.
Okay. Mr. Huber, just then to wrap this up, hit the third topic that I wanted to talk about, getting around to some ideas that were in your rebuttal testimony. Do you agree that we're at an inflection point in the utility industry?
Yes, in a variety of different ways, and I'll try to be brief because I could talk about this for hours. But
I can kind of direct you if you'd like. It's often said the utility grid hasn't changed much in about 100 years, but you would say things have started to change fairly dramatically recently.
Yes, I mean, you have so many large trends that are impacting the industry. And just, broadly as it relates to this program, I can just say you've got changing customer expectations and preferences, okay? You've got more and more cost-effective customer-cited technologies. You've got, more advanced meter and more advanced billing systems, right? You have a push for decarbonization. Those are pretty big. And then you add electric vehicles to it. Right. So those are some very big trends impacting the utility industry, and this program is a start on how to respond to some of these large trends.
Right. I guess the trends you're talking about could reverse the trend of relatively flat load growth over the past few decades.
Mr. Chairman, I hate to be a thorn, But I still am struggling to see how Mr. Kirkendall's questions directly relate to Mr. Huber's rebuttal testimony.
Mr. Chairman, if I could, I think the reason why I weighed in last time, and it seemed awkward when I said, this is the company's witness and I'm the attorney, and you said, I've got that, that's pretty clear, was I think the real question is the appropriateness of another party who's getting ready to cross-examine raising objections about another party's cross-examining of their witness. I mean, it's not ORS's witness, and what's their ability to object to a third party's line of questioning to this witness. I think that was a question that was raised, so that's my limited role in this.
Mr. Chairman, this is Mr. Bateman, if I may respond briefly.
Don't worry about it. I'll tell you this. ORS is a creation of the General Assembly, and they have some privileges afforded to them that are unique to them. I understand your objection, and maybe you have a case that I could read to help you with it, but I think I think that the objection is appropriate. Now, the issue is this. Are you going to start citing to pages of his testimony where he's not referencing certain items?
Mr. Chairman, I absolutely understand it's a double-edged sword, and to the extent I do that, I fully expect an objection and would expect even-handed treatment from the chairman.
All right. So your objection to his answer is his last answer was not, the question was not germane to his pre-filed rebuttal testimony.
And to be clear, Mr. Chairman, I absolutely agree that the chairman has broad discretion with this, and I'm honestly not even attempting to limit Mr. Huber's testimony. I would just respectfully request that the questions be germane to Mr. Huber's testimony. If the questions are not germane to Mr. Huber's testimony, as many of them have not been, then they're honestly all over the place regarding other witnesses' testimonies, regarding other issues that have been said in this proceeding that really have nothing to do with Mr. Huber's testimony, and for that reason, I'd respectfully request just a level of relation to Mr. Huber's rebuttal testimony.
All right, objection noted. Mr. Kirkendall, how much more cross-examination do you have, sir?
I have 1 point to raise.
All right, please proceed.
All right. Mr. Huber, it seems like one of ORS witness Horry's main complaints is that technologies that generate electricity cannot fit under the definition of energy efficiency. Let's think about a similar technology, a different technology for a second, battery storage that is charged from solar PV. Under your framework, would discharge from a battery to serve on-site load and reduce demand from the grid perform the same basic function as solar PV?
I need to think about that, but in general, it is providing something very similar. We just have to keep in mind that solar is producing energy, right? And battery storage is shifting. But at the end of the day, from a grid perspective, that battery is reducing, consumption on the grid and peak demand of the grid. And I think that's why other states have put storage into their energy efficiency programs.
And to your understanding, would Mr. Horry's definition of energy efficiency preclude adoption of that solar plus storage?
I don't think so. I'm still a little bit confused as to witness Horry's definition. If he's okay with CHP and solar hot water, but not okay with solar PV, I'm frankly a bit still confused on his exact position. So I don't want to overplay then say this is what he thinks. He's taking this sort of strict line And so my guess is he would say no to energy storage.
And I guess that confusion was what I was getting to. Mr. Chairman, I have no further questions for this witness.
All right. Office of Regulatory Staff.
Thank you, Mr. Chairman. Ms. Ford, I just wanted to ask you a few questions about the colloquy you had with Ms. Clancy when she asked about your participation in collaborative meetings when you were at the Office of Regulatory Staff. You recall that?
I do.
Okay. And remind me, if you can, when did you leave the Office of Regulatory Staff?
2016.
Okay. And you're aware, are you not, that the General Assembly passed Act 258 in 2018?
I am.
Okay. And you're aware that Act 258 changed the duties and responsibilities of ORS, are you not?
I am aware of that.
Okay. Thank you, Mr. Chairman. No further questions of this witness.
Mr. Chairman, would you prefer we cross Mr. Huber at the present time, or would you prefer Commissioner questions of Ms. Ford?
No, you go ahead and cross them now.
Okay, thank you, Mr. Chairman. Mr. Huber, how are you?
Doing well, thanks. How you doing?
I am good, thank you. Mr. Huber, I am correct, am I not, that if these programs were passed, it would result in an increase in rates for the company's customers, correct?
The RIM test, which looks at rates, witness stuff covered this. I believe DEC. I believe it was DEC. DEC, which is about where 80% of the solar is, that passes the RIM test, which shows that customer rates would decrease due to this program.
But these programs have incentives associated with them, correct?
Yeah, absolutely.
And these programs are, this is very basic, I hate to even ask it, but these programs are something in addition to what the companies currently offer, correct?
Correct.
So it's your testimony that the company can offer these programs, can include incentives with these programs, and that rates decrease.
Yeah, the cost tests confirm this over time. There is a decrease in rates due to these programs.
But when the programs are offered initially, you know, we may have the EM&V study in a year or 2 years. At that point in time, rates will increase, correct?
I get what you're saying now. In a shorter term time horizon, there will be the impact of the say the cost of the incentives through, I think, the rider, and again, this is witness Duff's territory, but there will be a small increase in the near term, and then to my point, offset by all the benefits through this program.
But to be clear, you testified to the RIM test, correct?
I'm citing the RIM test as a good way to verify my statements of that the eventual the benefits will outweigh the costs on the rate side of things.
And RIM, correct me if I'm mistaken, stands for Ratepayer Impact Measurement. Is that correct?
Correct. It's looking at non-participants.
Mm-hmm. And so, based on your testimony now, just to be clear, I am correct that in the short term, rates for company customers will increase as a result of these programs, correct?
It gets a little bit complicated because, and again, I think this is better for witness Duff, is that there's also a lag, and so that non-participants won't see the cost of this program for, I believe he said, till 2024. So there's benefits that accrue before non-participants see any of those near-term costs, and then they're recovered, and then it just depends on where the benefits are at that point, and then if some time later, possibly just a few years, the benefits outweigh those costs.
So, and I don't want to mischaracterize your testimony, and please let me know if I do. It's certainly inadvertent. But let me repeat what I think he said, and correct me if I'm mistaken. in the short term, customers' costs will increase and they'll pay those costs. But in the long term, benefits may outweigh those costs. Is that correct?
Almost.
Okay.
Mr. Chairman, I would object this has been asked, answered, and I believe this witness has answered to the best of his ability and said that the details about the EM&B is with Mr. Duff, and he stated that a couple times.
Mr. Chairman, if I may quickly respond. I only want to make the record clear, honestly, on this point. Additionally, in witness Huber's pre-file testimony, he did testify to the RIM test, which is the ratepayer impact measurement test, which deals exactly with these points that we're speaking of.
Yeah, I agree. And, you know, on an objection like that, Attorney Cooper, my issue would be that the witness's answers change with every question for me. And so, you know, don't feel pressured to answer a question you can't answer. Just answer the question and we can move on so that your objection is overruled.
And Mr. Hubert, the chairman's point, to the extent you can't answer this question, please let me know.
Right. So I can't answer the details that I would like to provide, but just high level, there's a period of time where non-participants receive benefits but no costs. That's right in the beginning. Then there's a time when they see some of the costs, there's still some benefits. And then over the long run, the benefits overtake the costs. So I just wish it's just not as simple as I think the statement that you're trying to make, but my limitation is I don't have all those details. Witness Duff has all those details.
Absolutely. Mr. Hubert, now on page 8 of your rebuttal, beginning on line 19, you did testify, I am correct that you testified, although it is noteworthy that the program passes the notoriously tough RIM test, correct?
That's what I stated.
Mm-hmm. So you assert that it passes the RIM test, but you cannot tell me with any certainty whether these customers will have to pay costs at the beginning or how much costs they'll have to pay. Is that correct?
I cannot, but witness Duff could, I'm sure. But what I'm doing is I'm looking at a cost effectiveness test that is notoriously tough to pass, which is why virtually no states use it at all, except for maybe one. And I note that that's a really good measure of the impact to non-participants. And these tests are over the time period of the program. So as I mentioned before, time periods and all, the time horizon is very important. And so when there's a question that's sort of broad, you have to like zoom in and be like, okay, well, exactly what time period are you talking about? Is this before we collect the costs of the incentives? Is this after? Is this before all ratepayers break even? And so there's just a lot of moving pieces to it, and all the specific details are just not in my purview.
So just to be clear for my benefit, Mr. Huber, you did not actually conduct this RIM cost test. Is that what I understand?
I did not personally conduct it, no.
Okay. Mr. Huber, I'm correct, am I not, that these costs, which will be borne by customers, will be borne by solar and non-solar customers alike, correct?
Yes, on the cost side of the equation, everybody chips in.
And Mr. Chairman, if I may ask to put a document on the substitute ELMO with the chairman's indulgence. And
did you check with the folks in the back? Okay.
Yes, sir. And I'm hoping it does not create technical difficulties. In the event it does, I'll certainly find a workaround.
All right.
Mr. Huber, you testified in the solar choice dockets regarding those tariffs' impact on the solar market, correct?
I'm not sure I went in depth on particular impacts of the solar market. I could have, and I'm just maybe refresh my memory if you could.
Sure. Mr. Chairman, may I approach the?
Yes.
Mr. Huber, I don't know that does you much good, does it? There we go. Thank you, Melissa. Mr. Huber, this is still a bit small. Can you read that?
I can read the question, but I did get LASIK and that's.
Mr. Huber,
Yeah.
I honestly would
That's
be
good.
happy to read it aloud, and you could let me know if you believe I mischaracterized it.
No, I can read it now.
Okay. Mr. Huber, would you mind reading that highlighted section, please?
The companies are able to provide a rooftop program that not only provides customers access to a robust net metering option, but also ensures that a broad range of interests is represented, sorry, I'm like squinting, to ensure that, or to avoid disruption to the growing market for customer scale distributed energy resources in accordance with Act 62.
Thank you, Mr. Huber.
I think I got most of that.
Yes,
Feels
sir,
like an
thank
eye
you.
test.
Mr. Huber, that was your testimony in that docket, correct?
That's correct.
So, Mr. Huber, you testified that those tariffs ensured a broad range of interests are represented to ensure avoiding disruption to the market for customer scale DER in accordance with Act 62, correct?
Correct.
I am correct then, am I not, that the incentive programs in these two proceedings are not necessary to comply with Act 62, correct?
No, I wouldn't characterize that at all. This is specifically tailored to a customer segment that can provide a substantial amount of benefit if we can get them solar energy and consume behind the meter along with that smart thermostat dispatch. I think that's the key point there.
But in the solar choice docket, you testified that those tariffs ensure a broad range of interests is represented to ensure, quote, to avoid disruption to the growing market for customer scale distributed energy resources in accordance with Act 62, correct?
That's correct. And the key word there is disruption, right? So what we're doing with the solar choice tariffs is giving a fair exchange of near-term value, guided mostly by the embedded cost analysis. Those tariffs are not what I would call, say, a straight fixed variable tariff, where you just say, hey, you're going to have a $100 fixed charge and then a very small volumetric charge. That would lead to the disruption that I think the Act 62 is getting at, which is industry's done, right? There's still a chance for the industry to continue to sell here. Will it be robust? I don't think so, given the participant cost test plus the complexity I was mentioning earlier. And certainly for customers that have electric heat, it is not a very lucrative offering. And that's who we're targeting in this program.
So to be clear that I understand, your testimony is that absent the programs, which the company has sought in dockets 2021-143 and 144E, the market will not be robust. Is that what you just said?
I think, I think in general, the solar choice tariffs significantly changed the economics for solar adopters. It went, I think if you recall, we had Witness Harris, and he was brought back at the commission's request to talk about how much more customers under the permanent solar choice tariffs will pay. And That being said, even though they're paying a lot, it's not like the complete end of the industry. However, especially for customers on RE, all electric customers, their rate design compensates them significantly less than RS. And so I would expect very low adoption on RE absent this type of program.
Mr. Chairman, I've put that document back on the substitute Elmo with the hopes that everyone could see that despite the fact that Mr. Huber has now testified that absent these programs, there will not be a robust market in South Carolina. In the solar choice dockets, Mr. Huber testified that there would be a robust market with that NEM option. So my question to Mr. Huber is, were you right then, or are you right now?
Mr. Chairman, I just have a point of clarification because it's hard to see. Could you please clarify whether the term is robust market or a robust option?
Mr. Chairman, Mr. Cooper is certainly allowed to object to my questions. I'm not sure he's allowed to redirect his witness during my cross-examination.
Mr. Bateman, I apologize. I was simply just asking about a word because it was hard to see over the...
So
to Mr. Cooper's point.
Did you make an objection?
I sought a point of clarification, but I'm happy to make an objection. It's really a request to make sure that this is in proper focus so everybody can see the words as they appear.
And
you can see.
I absolutely agree with that. To the extent folks cannot see.
I understand your question. Can we?
Mr. Chairman, this is Kate Mixon, and just on the WebEx, I'll note it is very blurry for us on the live stream.
What about now, Attorney Cooper?
Mr. Chairman, I can see that. I don't know if...
Attorney Mixon?
Yes, Mr. Chairman, if I make it full screen, I can see that fine. Thank you.
All right, thank you. Please proceed.
So, Mr. Huber, I'll repeat my question.
Sure.
I think essentially it was, you testified a second ago that these programs and docket numbers 2021, 143, and 144E are needed to have a robust marketplace. Likewise, you testified in the solar choice dockets that if the commission were to approve those tariffs that you proposed in those dockets, customers would have access to a robust NEM option. My question is, were you right then, or are you right now?
Right, and I reject the premise that you're building with that, because marketplace, and this is what I was saying, a subset, not, you're saying marketplace here. I'm saying in that testimony, that's a robust net metering option, I believe, and I have to look because you just took it away. But it's sort of funny that this is all coming down to the term robust for a number of different reasons, but this is in that testimony, this is a good option that a customer can provide. It's not straight fixed variable. It's a multifaceted, I'm trying to think of another word than robust, multifaceted option that a customer can engage in and try to drive some benefits from, okay? What I was just talking about now is I was talking about the RE customer subset. That is the focus of what I'm talking about now.
Okay, thank you, Mr. Huber. Mr. Huber, there has been much discussion about the MOU much discussion about the MOU that occurred in the solar choice docket in this docket. Have you heard that?
Yes.
And you were heavily involved in that solar choice docket, correct?
Correct.
And you were involved, I believe, correct me if I'm wrong, you were involved in negotiating that MOU, correct?
Correct.
And Mr. Huber, when was that MOU executed?
I cannot recall.
Subject to check, was it in September of 2020?
Subject to check, I agree with that.
Sure. And Mr. Huber, you've also heard the testimony regarding the negotiation that occurred between Duke and, I believe, the self-ascribed Clean Energy Advocates to determine the 39-cent incentive that Duke proposed to be applied in these programs, correct?
Correct.
And you've heard the testimony that those meetings occurred before ORS was made aware of the concepts of these programs, correct?
Sorry, can you repeat that?
Yeah, sure. That the meetings to determine the 39-cent incentive occurred before ORS was aware of these programs and concept.
Oh boy, I'd have to look back. I remember keeping ORS and Witness Horry well aware of how things were going, what we were trying to build towards with all the different parties. So we'd have check-ins, and so broadly, I'm definitely could have mentioned that that's where we were headed. I'm not, I can't recall precisely.
Is it your testimony that ORS was aware or involved in the negotiations to determine the 39-cent incentive?
They were, and I think this is actually a better question for Witness Forward, but my understanding is, and I was not in that meeting, but they were included once we got to the point where we had something. And again, I never even thought we could get agreement, right? And so I'm not going to also just burn everybody's time and then it just fails. But once it looked like we were there, the company met with ORS. I was not in attendance. I was testifying in another matter in another state. But again, Ms. Ford should have all those details.
And so,
I do have those if you'd like me to provide that.
not right now. I appreciate the offer, Ms. Ford. Mr. Hubert, to be clear, when you say once, and you may have said they or we, but once we were there, when you say there, you mean once the companies and the Clean Energy Advocates had come to a conclusion, then you let ORS look at it? Is that what you mean?
No, it was just more like, wow, like we could actually do this. Like we could put together this package and move forward. Again, there was times where it was like a complete no-go. This was never going to happen. Again, we kept ORS updated. And then when we're like, all right, something's here. Like this could do it. The company reached out to ORS to set up a meeting.
Okay. Mr. Huber, there was some discussion about the 1-to-1 rate yesterday. Do you recall that?
Vaguely.
Okay. And there was some discussion about Company Exhibit 4, which was the meeting minutes. Do you recall that discussion?
Yes.
Mr. Chairman, I'm going to request that Mr. Knowles place those meeting minutes, which have already been entered into the record, onto the Elmo substitute here. Mr. Huber, you have a copy. I believe your counsel has a copy. I do not, so I may wait until it shows up on the Elmo. Melissa, if you don't mind zooming in just a tad. Thank you. Commissioners, can y'all read this? Okay. Mr. Huber, do you see, thanks, Alex. Do you see this section about the 1-to-1 rate just below the underlining in on that page?
The Robbins, the 1-to-1 net metering rate is expiring soon.
Yes, sir. And correct me if I'm wrong, but it says now that incentive is winding down and another one is needed. Shelley Robbins the 1-to-1 net metering rate is expiring soon. Is that correct?
That's what it reads, but again, I don't think this is a direct quote.
Yeah, absolutely. I believe you're most likely correct. Thank you, Mr. Huber. Mr. Huber, now, to be clear, these programs are intrinsically linked to the solar, the programs that you're proposing in these two dockets are intrinsically linked to the solar choice dockets, correct?
As I've stated, the Solar Choice is the platform to which to build on, as the commission noted in their order. So yes, there's a linkage.
Yeah. And let's see. Mr. Huber, I'm correct, am I not, that the benefits of solar PV were calculated and included in the tariffs approved pursuant to the Solar Choice dockets, correct?
The general residential customers, yes, and but only the short term in costs and benefits. So again, we looked at this from embedded costs of service standpoint, which is, if everybody recalls, the big debate, right? Of do you switch your cost of service allocators midstream, break regulatory norms before a rate case, or do you stick with what underpins all of your rate designs, right? And remember the summer peak versus winter peak. So the rate designs are looking at like a 1-year look at embedded costs. These programs are looking 25 years, marginal only. So it's sort of the equivalent of giving a test to a first-year engineering student versus after they get a master's in engineering. There's a completely different different level of benefits of that education from year one to the end of their education. And so the Solar Choice tariffs looked at a near-term snapshot of embedded costs.
So your testimony is that those dockets, those tariffs, actually only included short-term benefits?
Yes, and so with rate design, you start to get into very dangerous territory if you base your rate designs off of benefits projected over many years. It's typically what you do is you say, hey, am I collecting my revenue requirement? And that revenue requirement, that's a near-term test, essentially, that you're doing. And so that's the key focus of the rate designs. Make sure that there's no near-term cost shift.
Mr. Huber, are you aware, and we touched this ground a bit earlier, so I don't mean to cover this again, so to the extent I am, I apologize, but are you aware of the impact to the company's customers when these incentives are added on top of the tariffs which were approved in the Solar Choice dockets?
Okay, so the Solar Choice tariffs are an equal exchange of value, okay, based on a short-term embedded cost analysis. And then, as mentioned before, for a certain subset of Solar Choice customers that have a particular load and engage in a long-term, transaction, essentially, there will be overall benefits outweighing the costs, but also there will be some program costs that have to be recovered from all customers.
Thank you, Mr. Huber. Mr. Chairman, I'm going to approach the modified ELMO one more time.
Mr. Chairman.
Yes, sir.
Well, I'll state an objection. It's really more of a clarification. Is this a document that's been emailed around? Is this a document that's going to be shown to the witness? Is this a document that's going to be handed to us as a cross-examination document?
Mr. Chairman, yeah, absolutely. I am not intending to enter these into the record to the extent they've not already been entered into the record. So I did not email them around, though there was no intent to hide it. It was just because I'm not planning on making these exhibits to the extent they're not already exhibits.
could you identify the document before it's published?
Absolutely, absolutely. To the extent I've not, I apologize. Mr. Chairman, on the Elmo, which will hopefully show up in just a second, I've put an excerpt from witness Ori's testimony. In this excerpt, and Melissa, if you don't mind zooming in on that graph right there, if you could. In this excerpt, he has pulled out, thank you, Melissa, a section, and witness Ori's testimony is already entered into the record, a section of witness Ford's testimony from the Solar Choice dockets. Witness Huber, do you see that?
Yes, I do.
And this directly relates to the one-to-one rate issue that we were just discussing. Do you see the bar on the left, Witness Huber, and below that it says full retail NEM RS?
Yes.
And is it your understanding that that is representative of the one-to-one rate? The payback period for the one-to-one rate?
It's roughly equivalent in, yes.
And Mr. Huber, do you see the bar on the far right, which is labeled beneath that, and this is small, I apologize for that, settlement with incentive, comma, RS?
Yes, I see that.
And that represents the payback period of the Solar Choice tariffs with the incentive that the company has proposed in these programs, correct?
Well, I mean, I'd have to see because, you know, basically we're doing this for RE and this is RS. And so I'd have to sort of think through what deck this was in and so forth. But I think as we've established that this is for customers that are all electric, at which I think, 99.5% of customers are on RE.
Mm-hmm. Mr. Huber, I honestly do not recall all that you've been qualified as an expert in, but I would wager you were qualified as an expert to testify to a hypothetical regarding these graphs, correct?
I would think so.
So hypothetically speaking, we take the RS piece out. Hypothetically speaking, the RS and the RE really makes no difference for purposes of this analysis. If that's the case, then the bar on the far right, settlement with incentive, comma, RS, is roughly equivalent to the payback period of the Solar Choice dockets tariffs with the incentives in these programs, correct?
Barring the whole RE equation and eligibility of having all electric heat, those graphs are roughly in line with each other.
And so these graphs show, Mr. Huber, that the one-to-one rate, which was intentionally put to bed, has been raised again through the Solar Choice dockets and these incentives, correct?
So there's a few important things. One is RE does not look like this. Okay, so I just want to make that perfectly clear. Number two, there's a lot of assumptions that go into this chart, as you can see from the right-hand side. There's different system sizes. We don't know how customers would respond to the actual complexity of the rates and system sizing. So this is a pretty rough estimate generally. And RE does not have that same type of equivalence that you're mentioning here.
But Mr. Huber, you are an expert. Hypothetically speaking, RS and RE is taken out of the equation. And to confirm, this is the company's chart, company's assumptions, company data. That chart shows that the one-to-one rate, which again, I'm sure there's a better way of putting it, but was put to bed, has been resurrected through these programs, correct?
No, we're not. We're proposing these programs for all electric customers. But so I agree that in terms of the charts are relatively equal in this hypothetical scenario. So we can establish that at least. But again, these programs are for all electric customers.
But hypothetically speaking, the payback period is roughly the same.
Hypothetically speaking, if the customer was eligible for this incentive, then yes, it would, that after the incentive amount would be roughly equivalent to the prior solar choice chart.
And the prior solar choice chart is the 1-to-1 rate.
Correct.
Yep. Mr. Huber, these programs have not been approved in any other state, correct?
To my knowledge, there isn't a state where this has been approved yet. I think, there's different stages of where this is all at. I think, Massachusetts, it's pending. But to my knowledge right now, there is no state that has approved it in their standard E programs yet. Just like, yet.
Mr. Huber, have these programs been filed in North Carolina?
No.
Do the companies plan to file these programs in North Carolina?
I think that's the general intent, yes.
Have the companies approached North Carolina public staff about filing these programs in North Carolina?
Yes.
And what was North Carolina public staff? Did they express an opinion about these programs?
Objection, Mr. Chairman. I don't know the relevance of North Carolina public staff's opinion before this commission. North Carolina public staff's not interpreting, unless I missed something. Maybe Mr. Bateman asked if North Carolina staff opined about compliance with South Carolina law. But if he's asking about a North Carolina program complying with North Carolina law, I don't understand the relevance.
Mr. Chairman, I'll withdraw the question.
I'm sort of interested in the answer. I mean, I don't want to argue relevance for you, but if the question is withdrawn, it's withdrawn.
Mr. Huber, we talked earlier a little bit about the idea of precedent. Do you recall that conversation?
Yes.
And Mr. Huber, you are not an attorney, are you?
I am not.
And you have no legal training?
Not formally.
Sure.
I was a lawyer in teen court once.
Mr. Huber, you do not understand the intricacies or nuances of a term like precedent. Isn't that correct?
That's correct.
Mr. Huber, you talked earlier about your having been invited to speak at multiple conferences related to the solar choice dockets. Do you recall that?
Yes.
About how many conferences would you say you've been invited to?
It's sort of hard to distinguish between like a webinar and a conference. So, I would say if you just combine like webinars and conferences, I would say, somewhere 10 to 15.
And Mr. Huber, did you receive a financial compensation for speaking at those conferences or webinars?
No.
Mr. Huber, do you have a financial stake in the outcome of these proceedings?
Not that I'm aware of.
Thank you, Mr. Huber. Those are all the questions I have.
Commissioner questions?
Mr. Chairman.
Commissioner Thomas.
Thank you. Good afternoon, Mr. Huber.
Good afternoon. Good late afternoon, Commissioner.
Good late afternoon. That's a good way to put it. Okay, it's been some interesting discussions here, and I guess probably this question would be for Mr. Huber. You were talking in general about this being an inflection point time for the utility industry, and you're talking about just how rapidly things are changing, and anything from I think meters to the technology to whatever. I can't even remember all the things that you named, but it's obvious that you were talking about rapid change in technology, and I mean, I guess that could apply to the solar industry and batteries and the solar panels. I mean, are you really thinking that there's going to continue to be rapid change in all of those areas?
Commissioner, I think we're going to see more change in the next 10 years than quite possibly the last 100. There's so many different things occurring and impacting the utility sector. The technologies are rapidly evolving. Politics is ever present, impacting the industry, and the urgency to decarbonize is happening all at the same time, while we've got the possibility of a huge change to transportation. And I mean, if we can just, take a step back and think about the Ford Lightning, the pickup truck, the base model, I think, is 100 kWh battery. That's like 9 power walls just sitting in a garage. So if there's 1 million of those, Ford pickup trucks, and we can only access the 10% of the battery, that's still like 10 gigawatts of possible capacity to use. The numbers just are staggering, but at the same time, there's a lot of challenges. There's more and more extreme weather events, and you have to plan for that. And that's not just with having generation, but that's your distribution system. Duke's distribution system literally wraps around the world several times. That's how many miles we're talking about. So think of the complexity of that network with extreme weather. And now you're trying to balance the grid with variable generation, large scale, and always variable load. Now with electric transportation, how critical is that, right? To a household, how critical is having power for internet and so forth. So the responsibilities are growing right as we're in the midst of this large transition.
Well, all that makes a lot of sense. It really, really is hard to imagine just how things might change and how rapidly things might change. And I guess just given that, that we're expecting so much rapid change, do you think it's fair to lock customers into a 25-year contract in this program, given that things are changing so rapidly? Seems to me that the company is pretty well protected under that 25-year contract, but the customer's kind of in there with it. And if things change rapidly and new technologies become available that could just totally supplant what we're dealing with in this program, that the customer's locked into a 25-year contract. I just, can you explain to me how that is fair for the customers?
Yeah, in developing these programs, and we've hit on this, you have to provide that holistic view of non-participants, of participants, and making sure that you actually capture the benefits that you're modeling and keeping costs low. 25 years is a long time, but when you think about it, panels last a very long time. I mean, probably at least 25 years. They'll go on. And so I think that requirement of 25 years is fair given the exchange that is going to be happening with non-participants for that upfront incentive, and the fact that a customer, as long as they provide us with that demand response, they can adopt new different types of thermostat technology as long as it's eligible for the program. So our program will continue to evolve and incorporate new technologies, new different types of thermostats, but having that key dispatchability and control over the HVAC is absolutely key. And so whatever happens in the future, there'll be flexibility just as long as those demand reductions are actually there. And that's really what that contract is all about. That customer will be delivering through their HVAC system, I think, over 1 kW of peak demand reduction. And so technologies might evolve, but as long as that thermostat technology might evolve, but as long as that key point is taken care of, I'm sure there's going to be flexibility as things change around that particular set of customer technology.
Okay, so it sounds to me like you think that the contract will accommodate technology changes and that customers will be able to take advantage of these rapidly changing technologies. Is that what I'm hearing you say?
That's absolutely correct, yes.
Okay. Well, that's good to know that the customers will have the flexibility and ability to change with the times. So then I guess another question would be is, do you expect this program to continue to grow over time?
Good question. I would think so, but I'm just not sure because there's, as noted, this is a new offering. And the last thing I'd want to do is be like, oh, this thing is going to be super popular. This honestly might not be popular. I do not know. I've noted some complexities of that Solar Choice platform. We've just talked about the 25 years. And I don't want to be the guy that's like, oh, this is like the Segway, it's going to change everything. Everyone's going to love it. It's like, I'm not exactly sure how customers will receive this program. I'm hoping they love it. I'm hoping that there's adoption. I'm not 100% sure at this point.
Okay. So basically the program's been put together hoping and maybe planning, but certainly at least hoping for continued growth of the program. So let me ask this, as an EE program, the company would be collecting the lost revenues because of increased solar customers from other customers, correct? That's my understanding.
So there's I think a 36-month window where the net loss revenue would be collected from from everybody, I guess, paying the rider, unless there's a rate case, is my understanding. Witness Duff has all those details, but that's my understanding of how this works. It looks at just that self-consumption adjusted for a myriad of different things based on that M&V, the independent M&V evaluation.
Okay. So if I understand that correctly, then at least over the short term, maybe up to as many as 3 years, as the program grows, then those lost revenues would perhaps be collected from fewer customers, assuming that people are migrating away from just being a regular customer to being one of these Smart Saver Solar customers. There'd be fewer regular customers to recover those lost revenues from over the short period. Is that correct?
No, Commissioner. We have non-bypassable charges for these customers so that they have to continue to contribute into these programs even if they are part of this program. So there's no loss of contribution if they participate in this program.
Okay. Thank you. That's all I have.
Commissioner Caston. Commissioner Caston, you have the floor, sir.
Good afternoon, Mr. Huber and Ms. Ford.
Good afternoon.
My mom taught me that ladies were first, or if it's okay, Ms. Ford, I'd like to ask you a question or so.
Absolutely.
Commissioner Caston.
Video on here. Sorry, I thought I was on. I think I missed this, but were you a participant in the collaborative meeting that's been previously discussed? I guess the first collaborative meeting.
The DSME collaboratives that took place in November and then earlier in 2021?
Yes, ma'am.
Yes, sir, I was.
Well, I think it was 2020, wasn't it?
Yes, sir, November 2020 and then into 2021. Yes, sir, I was a part of those.
And is that, excuse me, is that the same meeting that is listed in item 4 of the application? Result of collaboration with Southern Environmental Law Center, South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, North Carolina Sustainable Energy Associates, Sunrun Inc., Boat Solar, and Solar Energy Industries Association.
And just to clarify, you said page 7?
I'm sorry, actually, I'm just looking at the application. I apologize. That was in Witness Duff's Exhibit number 2, page 3. It's Duke's application for this program.
I just want to be completely clear that I am giving you the correct answer. And I'm sorry, Commissioner, do you have the page number for Mr. Duff's Exhibit 2? Was that the page 7? Page 3, okay.
Page 3, item 4.
Okay, thank you. I appreciate that. That would be different than the November collaborative meeting that took place. Those collaborative meetings that were referenced in the application, at least in that section, are addressing ones that evolved out of Act 62 and the passage of Act 62. We were looking at future solar choice metering offerings, looking at that Act 62 required the generic docket to look at the benefits and the methodology of the existing net metering program. And as an evolution and looking at innovative solutions for South Carolina, that resulted in a settlement agreement, an MOU. And then the energy efficiency component of that was conceptual in nature. A 36-cent per watt incentive was negotiated, and then the actual program and kind of the meat on the bones was not there. That is when Duke took that to the DSMEE collaborative beginning in November, and then I believe in 3 subsequent meetings to work with those stakeholders to actually put the meat on the bones of the program.
All right, I want to make sure I understand this. When was this 36-cent incentive meeting where that was decided?
Sure. So we had several stakeholder meetings that began in March of 2020. We had one in March and then April of 2020. This is with a group that is different than the DSMEE collaborative. This group was looking at Act 62 and implementing, certain sections of Act 62. And in that discussion, there were also some stakeholders showed interest in really almost kind of pulling together a strawman's proposal for the group. And so those groups met throughout the spring and the summer of 2020. And throughout the process, stakeholders were updated on, as we're kind of developing things and where we stand. So I mentioned the 2 stakeholder meetings. We had several individual stakeholder meetings. September the 10th, at that point, we had a strawman's proposal from the smaller work group. That strawman's proposal was presented to ORS on September 10th for consideration. The 36-cent per watt was presented at that time, as well as, solar choice metering tariffs. And then the MOU was signed September 16th, and then we notified the commission September 21st. Then, after we had that MOU signed, we presented it to a broader stakeholder group that also did include the original, parties there on September the 23rd.
Those stakeholder meetings in March, April, who was involved? Who were the stakeholders?
Sure. So it was Duke Energy Carolinas, Duke Energy Progress, Dominion Energy, the Office of Regulatory Staff. I know that there were, I believe the Southern Environmental Law Center was there. I'm not sure if they were representing the parties that they're representing in this case, which would of course be, Upstate Forever and Coastal Conservation League, those folks. Vote Solar, Sunrun, we had the Chamber of Commerce, Small Business, trying to remember the group that Frank Knapp represents, the Small Business Chamber of Commerce, I believe it is. We had manufacturers, we had solar developers, solar users. It was a broad group. I also believe there were low-income advocacy groups and AARP as well.
And these meetings in April and March of 2020, this is when this 36 cent was discussed and decided.
It was in the development during those meetings. We started off talking, kind of casting a very wide net. What are options for a new solar choice metering tariff going forward? And we looked at, what's going on throughout the country. Some places have a demand component, a demand charge. Some do time of use. Some do critical peak pricing. There are options like a grid access fee, a minimum bill. As Mr. Huber mentioned, some of them have a really high fixed charge to ensure that that fixed charge is recovered, and then a much lower variable, a cents per kilowatt hour charge. So we basically kind of threw it out all on the table, and through the process got feedback from parties. Some of them say, hey, this is kind of a non-starter for us, and worked our way through it. As we got the feedback from the much larger group, then we had a smaller work group that took all of the feedback and took, the ideas from the parties and started to develop the solar choice metering tariff, and then ultimately looking at innovative solutions, and one of those was energy efficiency.
Okay, I'm trying to follow it all because
it's a lot.
It is. I think during some previous question that it talked about conceptual meetings and this stuff. What I'm really trying to just get a grip on or understand better is relative to decisions that were made that established numbers or something of that sort. Who was there? Who was involved? Was ORS involved with it? Was the consumer advocate invited? ORS invited? I mean, who was involved in the meetings where numbers and decisions were made?
Sure. So I do know from the company's side, there were folks, and I don't know who they are personally, but there were folks that said, okay, kind of here are our parameters. We know if, we give an X amount of a rebate, then this is not a cost-effective program, and we can go, or we can go up to Y before it starts failing cost tests. So I know there were parameters that were in place. And then the attempt of the small work group was to develop a strawman's proposal to actually move us forward. And so that group, I would say, had, because this was going to be a Duke-specific program, it had, Duke Energy Carolinas, Duke Energy Progress. I know there were solar developers, and I'm trying to think, probably clean energy advocates. And they were the ones that had shown interest in developing that strawman proposal. We had opened it up to all, but they were the ones that showed interest in developing it. So we had that smaller work group that developed the strawman's proposal, and then started to do, as you do in a settlement negotiation, start to cast it out and present it and say, hey, here's our initial offering. Is there any interest? Can we work through this? Can we find common ground? And that's what started, I would say, early September, with the meeting with ORS that I believe took place September 10th.
So what I'm hearing is that the meetings, the early meetings, the small meetings, the straw man meetings consisted primarily of the Duke companies and the solar interest and such. are you telling me that there was no interest from ORS or consumer advocate, or were they invited and just decided not to show up?
We had in our stakeholder meetings talked that we were going to work through options, and I believe ORS has made it their position that they're not going to help in the development of program that they would ultimately regulate, and so I think that was clear. We did actually have additional, we're talking about this one specific, option, the one that came to fruition. We did have other discussions with other developers, with industrial customers, and other parties looking at a lot of different options. And as Mr. Huber said, a lot of times we didn't think we'd get anywhere. And with those, we weren't able to make the progress that we ultimately were with this group. So we had several different, stakeholder meetings going on.
I understand that. Last question.
Sure.
What I think I understand, and if I don't understand it, pick it up now. For whatever reason, the only folks that were at this smaller meeting, this straw man meeting that kind of decided on numbers were the Duke companies and the solar interests that maybe were listed there. Is that a correct statement?
I would say, yeah, it is those that ultimately sign the stipulation. They are the ones that showed interest in developing the straw man proposal. That's correct.
Okay, thank you. If I might ask Mr. Huber a few questions. Thank you so much, Ms. Ford.
Thank you.
Yes, sir. Go right ahead.
Okay. Mr. Huber, are you familiar with the US EIA?
Yes.
Do you agree with the US EIA's definition of EE?
No, and I think there's other federal agencies that probably disagree as well. But I think that's much too narrow of a definition.
So your testimony is that you do not agree with the US EIA definition, correct?
It would be helpful just to have in front of me, or if you want to read it one more time, but when I reviewed it, I thought it was too narrow.
Do you want me to read it?
Yeah, please, yeah.
Give me a minute, I've got paper scattered everywhere. Just a second. Now, let me say, actually, the only place I can put my hands on it right now is I'm reading directly from page 5 of 31 of Mr. Horry's direct testimony, where he provides a definition. So if you want to double check it to make sure it's correct, that's okay. Do you want me to read this one?
Sure. Yeah, if you want to read that, that'd be great.
It says energy efficiency is using technology that requires less energy to perform the same function. Using a light emitting diode, LED, light bulb, or a compact fluorescent light, CFL bulb, that requires less energy than an incandescent light bulb to produce the same amount of light is an example of energy efficiency. And I think that is use of energy, explain energy efficiency and conservation, EIA, and it's got a website.
Yeah.
Do you agree with what I just read or not agree with it?
So first, thank you for reading that. Second, I disagree, and here's why. I just don't think we have energy efficiency programs just to say use less to use less. It's all about the impact to the grid. It's typically, and again, this is maybe where the federal government's coming in, but typically if a citizen's actions do not impact others, you sort of say, you do you in a way, right? it's their choice. They're not impacting everyone. When you're connected to a grid, a shared infrastructure system, that's completely different. Your usage impacts others. So let me just, try to give this as an example. We don't go in and say, hey, how are you using all your devices that use AA and AAA batteries? How are your candles at home super efficient? We really, I'm saying both the utility and I would, assume the state of South Carolina wouldn't necessarily care what a customer does in terms of just their energy decisions that don't impact anyone. We don't say, hey kids, don't use the flashlight that much. You're wasting energy, or you get a better flashlight. It's just not what we typically focus on, because what we're focused on is the shared infrastructure system where one customer's impact can impact others. And so that's why I think that definition is too broad, but it might make sense for a federal government that wants to look at and regulate everyone's energy usage on everything that they do. That might make sense. I don't think it's a state, certainly it makes sense for the state or utility.
Well, I've observed through the course of my tenure here that in multiple proceedings, EIA and other government agencies are mentioned and referenced many times. And it seems that the argument is usually we should accept what they say here or there. So if I'm hearing you correctly, it is a moving target, and there is no definition for EE.
Commissioner, that is correct, and we see that with where South Carolina comes out on that. We know the federal government sometimes sends missed signals. I believe the EPA and the DOE have different definitions. The DOE has weatherization programs that include solar energy, and if Witness Horry is going to start pulling things from the federal government, well then, where were all the non-energy benefits from the federal government? Where were the social costs of carbon from the federal government? Where's less reliance on imports? I mean, there's so many different things that you can pull into when you start getting to the federal level. Sometimes it's a good guide, but I go more to the state for guidance.
I understand. Let me ask you this then. How, if it is a moving target and we don't exactly know what the definition of energy efficiency is, how can we have an Energy Star rating? Or how do I know if my refrigerator is really energy efficient? Because the definition might change next week. Or it was this week. What determines my appliance's energy efficiency if there's no standard?
Well, the end use efficiency measurements are different than, I think, just a broad umbrella of what's labeled energy efficiency in general. I mean, if you keep a definition static and there's new technologies, then would you ever include those new technologies? I guess there's a bunch of different standards at place for individual appliances and what deems them Energy Star. There's testing that takes place in labs around that. But I think what we're talking about more is just the global definition of what is included in energy efficiency and what do we care about? Do we care about a customer's use of a device that uses AAA batteries, or do we care about how they interface with the grid?
And Commissioner, may I chime in? I don't know if that's allowed or.
If I may, let me finish with Mr. Huber, and I'll be glad to come to you, because I want to make sure I'm grasping this. Then by your definition, Mr. Huber, would it be energy efficient for, let's say, to affect the grid? If energy efficiency is only the thing that affects the grid, then and I'll agree, an energy efficient appliance or energy efficient home or some DSM rooftop solar, whatever, all those things can affect the grid, you know, reduce the demand on the grid. I agree. But with your definition, which I'm not really sure what that is at this point, and I'm gonna give you an opportunity to kind of hone in on it some. Would it be considered energy efficient, energy efficiency, if, let's say I flip the main circuit to my house for 3 hours during the day, I'm using less electricity. Matter of fact, I'm using zero. Would that classify my house as an energy efficient house?
So again, I think Commissioner, we're getting to just questions of like end use product definitions of how do you deem an energy efficient house? And I think that's another thing that varies by state probably. But I mean, if you're turning off your service panel, you know, that's very much like the DR programs we offer, especially to large customers, where we say curtail your load and shut things down for an event. So that would fall under the broader demand side management programs and energy efficiency programs if you're curtailing your load to an event.
So if I'm understanding you correctly, if I did something like that, it is this demand side management, not energy efficiency, correct?
Yeah, and demand side management is the broad umbrella. Underneath that, you have energy efficiency and demand response.
Okay, then to carry it further, and then I'll quit, I promise. Then for me to know that it's demand side management and not energy efficient, for me to know that it's not energy efficiency, I would still need to know some definition of what energy efficiency is, so I'd know which category I'm in. Correct?
Yes, and I guess, you know, I think Witness Def and maybe Witness Ford have all the handy definitions, but that's where I just encourage to look to how the state or approved utility programs define the delineations between those different categories.
And while you're on that, if I may, if I recall, I gotta find where it is in the testimony. I think it's page 3, lines 20 to 22. Are you saying, on page 3, line 20 to 22 of your testimony, that solar PV is an EE device because of your interpretation of the Commission's generic docket and solar choice docket as classifying it as such?
I guess what I'm trying to say here is the Commission gave pretty strong guidance of how to treat self-consumed solar energy. And I looked to the Commission for that guidance. Other witnesses looked at state statute definitions, but I did use those quotes as guidance for me as I looked at the matter at hand.
So are you saying, again, I'm not trying to put words in your mouth. I want to make sure I understand this. Are you saying because of these dockets, or at least your interpretation of these dockets, that you, or I guess if you think this, does Duke Energy think this, that because of these dockets, that this commission has redefined the definition of energy efficiency?
No, Commissioner, not at all. This is not the sole definition that the company relied upon. by any means. I think the other witnesses have talked about, other definitions that support this. And I don't think the commission really redefined anything in the order to meet reaffirmed guidance. Again, solar hot water, CHP, it's, this is a fossil fuel generators is included in energy efficiency program. So to me, the commission just reaffirmed what I understood to be the definitions and approach of the state of South Carolina.
I'm trying to follow you, but if I understood you correctly, you were saying, I thought I understood you to say that the way you interpreted these, it changed that definition or gave you the definition of EE, but no. But I thought I also heard you say that, no, we didn't change the definition of EE. I'm sorry, I'm trying to follow. Could you kind of be more succinct or make sure I understand?
Sure. Apologies for the confusion, but I'm not making any claim that in your recent order that I referenced that you've changed anything. To me, you've reaffirmed the policy of the state and how we've structured programs like CHP in the past.
So you're saying that the state policy or state definition of EE is a moving target and undefined, and it isn't what EIA says it is? Is that what you're saying?
No, I just generally there's like when nationally there's a lot of viewpoints nationally, okay? And that's why I say even within the federal government there's some probably conflicting definitions between agencies. That's why I say it's to me better to look at where the state is on a particular definition. And to me, the state has a broad statute of what is under this broad umbrella of energy efficiency. Hopefully that helps.
No, sir, I'm sorry, it doesn't. I wish it did too. But what I'm trying to determine from you and from Duke Energy is what your definition of energy efficiency is. Period. Because if I go into Lowe's or whatever and I look at an energy efficient refrigerator, it tells me if I use this refrigerator over here, I'm gonna spend this much instead of this much. I'm getting the same cooling on my vegetables and fruits, but I'm using less electricity and it's going to cost me less. And I think I'm hearing you say that the definition is different for the state than the government. And I promise you, I'm not trying to be combative, but how can I know what energy efficiency is if I don't know what the definition of it is?
Yeah, and Commissioner, what I would do, and this is, putting on my former hat, if I was your advisor, and I've been in these positions before advising commissioners, I would say you've got to look at the state definitions. That is sort of a core grounding. And then from there, look at what the commission has included under the umbrella. There's, energy efficiency is just a broad term. It's just like fuel efficient vehicle. What's a fuel efficient vehicle? The federal government might have one definition. The state of California might have a completely different definition or a more stringent one. And the federal government might change their minds at the next administration. And then there's specific ratings on cars. So is a specific rating to, I think, what your point when you go to the Lowe's, but like a car has a 30 mpge is now, I think, the latest thing. But those are specific ratings that guide consumers on what a specific product will do. But definitions, for broad categories of technologies that are always evolving, there will be some conflicts between states and the federal government.
Okay, well, last question on this, I promise, on this particular issue. Can you tell me what the state definition of energy efficiency is, so I can write it down and know what at least know what you're telling me the state definition of EE is? My background's civil engineering. I know what I've been assuming it was for a good long period, but if I've been assuming it wrong, I would appreciate the definition, the state definition of energy efficiency.
Right, and I will let Ms. Ford handle that question.
Commissioner, I actually have it in front of me, and it comes from section 583720. And I will at least read a portion of it. It says that the Public Service Commission may adopt procedures that encourage electrical utilities and public utilities providing gas services, let's see. Okay, subject to the jurisdiction of the Commission to invest in cost-effective energy-efficient technologies and energy conservation programs. If adopted, these procedures must, and it talks about providing incentives, cost recovery, kind of the money part that we've been talking about, like the net loss revenue, PPI, those types of things. And then it says for energy suppliers and distributors, so Duke, who would invest in energy supply and end-use technologies that are cost-effective, environmentally acceptable, and reduce consumption or demand. And so I think that's why when you hear everybody talking about this is a reduction in consumption, this is not looking at exports like the prior net metering program did. It's because this is a reduction in consumption, along with with 583720. And then further along, it actually gives a definition of demand-side activity. And so I know you were asking earlier about, is it energy efficiency, is it demand reduction? Under 583720, and I'm not an attorney, but my opinion is it actually does not delineate between the two. It lumps it all together as demand-side activity. And so it further goes on to say, for the purposes of this section only, the term demand-side activity, which is in quotation, means a program conducted by an electrical utility or public utility providing gas service for the reduction or more efficient use of energy requirements of the utility or its customers, including but not limited to utility transmission and distribution system efficiency, customer conservation and efficiency, load management, cogeneration, and renewable energy technologies. And so I think, as Mr. Huber was saying, the EIA is one of many, many, many definitions of energy efficiency. Some focus on the end use, like you're saying, the appliance, and what is the rating of that appliance, and what are the standards there. But when developing this program, I think the companies went to 583720, the governing statute for energy efficiency and demand response programs. And then the order you referenced, I think, further supported 583720 in support of this program.
Ms. Ford, I'm familiar with that section too. Read it many times during this here proceeding. What you have read, and I think what I've heard Mr. Huber say, is that you're saying the definition of energy efficiency is what you just read. I'm not sure that I can concur that one might interpret all of that as saying that, but I guess that's to be determined. So I think it's gotten at least me to the point to where I understand, and don't let me put words in your mouth, that Duke Energy is saying that energy efficiency, as defined, is defined by section 58-3720 and the NEM and solar choice orders, and that the commission and the General Assembly has redefined EE as previously known to mean a whole bunch of other stuff as you just read. Is that correct?
I would tweak that. So I would not say that 583720 has been amended. That is was not modified. And so I think when looking at 583720, which is what Duke files its suite of energy efficiency and demand side management programs, file it in compliance with 583720. And so when Duke, any program, energy efficiency or demand side management, before proposing any of them, I think the first step is it in compliance with 583720? And, we would argue that checked the box here, that it reduces energy consumption or demand. It's a reduction from the requirements of the utility. It promotes, it's a renewable energy technology. There's also a load management component. So I think it checks multiple boxes with 583720. I think the point that, and I don't want to put words in his mouth, but I think the point you were asking about Mr. Huber and the order, I don't at all think that changed anything within 583720. If anything, it supports that programs and innovative programs they fit in with 583720. So I would not say that it modified it. I don't think it did that at all. 583720 is there. I think it's just one element that further supports the argument from the companies.
I have a couple more questions for Mr. Huber, and I promise I'll be through. But that said, and what you said is, if I had to describe or define what EE was, it'd be demand response. It could be a host of things, but it's not a thing. And I must be honest with you, I'm troubled by that, but that is certainly the way you say Duke interprets it. That's the way you interpret it, Mr. Huber interprets it, and I understand that. If I may ask Mr. Huber a couple of questions. I appreciate it, Ms. Ford. Thank you very much. Mr. Huber, a couple more questions, and I'm through, I promise you. I think during your cross with Mr. Kuykendall, and I didn't write it verbatim because I can't write that fast. But he asked you something about obviously the proposed program. And you said something to the fact that if Duke can offer something that benefits all customers, they should certainly do it. I think you said like apple pie or something like that. Do you recall that?
Yes, Commissioner. I think I was making the point of if you have a triple win, right? All customers, participating customers, company, that's sort of a no-brainer, and the utility would move forward with it.
I understand. Thank you. Well, as I understand it, the TRC is the test that I think Duke Witness Duff and perhaps others kind of dismissed the most. And the TRC, as I understand it, is the only test, the only one of the four, that looks at the cost and benefits for all customers. For all customers. As I recall, even in Duke's numbers, the TRC scored less than 1. So if your response to Mr. Kuykendall is accurate, why should not the TRC be given prominence in the cost-effective analysis?
Oh, great question, Commissioner. So there's a lot there. One is I do believe, and it's in Witness Duff's testimony, that that for DEC it passes the TRC. and DEC is where 80% of solar would be. But let's just talk about the TRC, I guess, more generally. When you have the other cost tests, you don't really need the TRC because the other cost tests give you what the TRC summarizes. And further, I just want to highlight, it treats private investment as a cost, but says that the incentive, this thing that we've all been arguing about, it's the, say, $3,500, that's not even treated as a cost in the TRC, right? So if I was talking to a citizen on the street and said, hey, would you like this cost test? And this incentive that'll be paid, that's not even treated as a cost. But somebody's private investment is. And by the way, then with that private investment, do you factor in what if a customer takes out a loan? That money comes from some other state. That investment comes from another state. And what if their loan's 3% and we use a discount rate of our weighted average cost of capital, so it's say 6.6 or something. If you look at just a simple calculation, it takes probably, take witness Horry probably 2 minutes to do it. You would see that just that loan at say 3%, which is a standard term right around now, and our discount rate, it would drop the cost of that solar 30%. Then what happens about federal incentives as they change? It's such a moving test that just, again, you don't really need when you've got the rim test and the participant test there. So that's just, I guess, just to start on your question. I'm sure there's follow-ups, but I could go, a lot longer on all these different tests. But at the end of the day, I think it doesn't provide you what you're really looking for in the TRC. I think the other three tests are more valuable in this particular case.
Okay. You both have been very patient. I appreciate you letting me take so much of your time. Thank you very much. No more questions, Chair Williams.
Thanks.
All right. We're in recess until 6:35. Good evening, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in dockets number 2021-143E and 2021-144E. So we've come to the point this evening where we're going to recess. We will come back tomorrow at 2 p.m. And if we don't finish tomorrow, we will reserve time on next Tuesday. Are there any questions?
Mr. Chairman, this is Andrew Andrew Bateman with ORS. No questions. I just ask that you confirm that the two witnesses are still under oath.
Confirmed.
Yeah, if you don't mind.
Yes, sir.
May I ask Mr. Huber a procedural question related to what you just mentioned? Yes, sir. Thank you, Mr. Chairman. So Mr. Huber will plan to appear in person tomorrow. Mr. Duff has been excused from the stand, and he's remote. He lives remote from here, and we would ask just that he be permitted to log into the WebEx tomorrow rather than appear in person. He's not scheduled to prepare or present any testimony tomorrow. But just I wanted to be sure that was okay with you, Mr. Chairman.
Absolutely. Appreciate you checking. Okay. So tomorrow, 2 p.m. All right. We are in recess.